Law School, Hyderabad. It is an honor to welcome you to today's event, ma'am. With an impressive 28 years of teaching experience, you bring a wealth of knowledge and insight that will undoubtedly enrich our academic environment. Your dedication to education and your commitment to inspiring students are truly commendable. We are excited to learn from your expertise and to benefit from the unique perspectives. Dr. Anuradha Binnuri is currently serving as a Deputy Director and Associate Professor at Symbiosis Law School, Hyderabad. Thank you for joining us and gracing this occasion, ma'am. We welcome you, ma'am. The second resource person I would like to welcome Ms. Manasa Krishnakumar, Assistant Professor, Crescent School of Law. She is currently working as the Assistant Professor at Crescent School of Law. She is also the faculty in charge of the Crescent Research Committee. She holds her LLM degree on Constitutional and Administrative Law from the National University of Advanced Legal Studies, Kochi. She has a wealth of experience in the field of constitutional and administrative law. She has made significant contribution to both education and research. She has a member of the Board of Studies for the UG program, and she has also been the part of curriculum development cell at the university level. I welcome you, ma'am. I thank all the resource persons for joining us today. Thank you, ma'am. It is also an immense joy that our coordinator, Dr. Professor Vijay Lakshmi ma'am, has also joined this. And she's always been the backbone of our institution, and she helps us in all the, this success of this event goes to her also. Thank you so much, ma'am, for joining us. You can press. Now we shall move with the presentation. So now we'll begin with the presentation. For the first presentation, I would like to call Ms. Tarini and Mr. Mohan Kumar KP to present their paper on the title, Federal Constituents in India's Making, the Fiscal Landscape.
Greetings to the esteemed chair and co-chair of this session. We are delighted to present our paper on the topic, Federal Constituents in the India's Making, the Physical Landscape. Now, this is a doctrinal research on this topic with the objectives of examining some of the major physical policies which have shaped the India's physical landscape. Yes, ma'am. Sure, ma'am.
Where are you from?
Yes.
Where are you studying? Which college?
Yes. Greetings, ma'am. Myself, Tarini S., studying third year BCom LLB at School of Law, Satyabama Institute of Science and Technology. And
I'm Mohan Kumar, studying BBA LLB Honours third year from Satyabama Institute of Science and Technology.
ma'am, if I may resume. Thank you, ma'am. So this is a doctrinal research with the objectives of examining the physical landscape of India. Now, while we talk about the physical landscape of India, it is very detrimental to look at the history, the commissions that were formed, and how far we have come in the influence of physical policies. Now, next slide, please. First, let's have just a gist of what federalism is. Federalism is essentially the decentralization of powers and authorities amongst various tiers of governments, that is the central, state and local government within India. Now, whether India is a federal state? No. The answer is ultimately no, because we follow the quasi-federalist system, which retains residuary powers at central level. The reason has the reason has been the same for over the years when we talk about quasi-federal system. That is because the state retains this residuary power to ensure that there is no imbalances within the state. Because when we talk about the states, when it comes to the factors such as the population, the length of the state, and the natural resources that the state possesses, all these factors are detrimental to this particular quasi-federal nature of India, because it balances the power and it ensures that the sovereignty of India remains intact. Now, when we talk about physical federalism, we have to talk about the principle of equity. Why this is important is because the principle of equity comes into picture when we talk about India. Now, India is a quasi-federal state and there is residuary powers with the central government. But when we come to every state, the factors such as the population of the state, the resources that the state has entirely differs throughout the India. Now, the center plays the role of being the residuary power. Next slide, please. Thank you. To balance out the horizontal and vertical imbalances. Now, the horizontal imbalances occurs when two states compete against each other. When we talk about competitive federalism, two states go against each other with different wealth resources. And what happens is that because of the lack of resources that one state possesses, the other state has an undue advantage when it comes to the system of taxation, getting tax from the center according to Article 270. So horizontal imbalances has to be balanced by the central government. But there is also this one very widely known factor, that the political pressure for decentralization in India stems from the concern of the states that political power might only benefit the major constituencies and not the minor constituencies. Now, this is the problem, that one of the lacunas in Indian federal system. The second lacuna is the vertical imbalances. Now, when we talk about vertical imbalances, it is about the high degree of centralization of revenue collection that occurs. Now, at this juncture, we have to remember cess and surcharge. That is, tax in India is distributed uniformly with the Finance Commission's recommendations by the central government to the states. But when we talk about cess and surcharge, it is only given to the consolidated funds of India. It is deposited into the public account of India, and union government has the ultimate power to decide whether this is being transferred to the state or not. So the state ultimately loses its physical resources when it comes to the concept of cess and surcharge, and this is where the concept of vertical imbalances arise. Next slide. Now, when we talk about the evolution of landscape, it is very important to look at the history, which is the Rajmanar Commission, Sharkarya Commission, and the Finance Commission. Now, the Rajmanar Commission was constituted in Tamil Nadu by the then DMK government in 1969. One of the major contributions of this commission was the recommendation that Finance Commission should be a permanent body in India to adjudicate matters related to this. Now, this is true with the present scenario, where Finance Commission recommends to the central government regarding all the physical transactions that happens between the center and the state. And further, this commission also talks about the readjustment of 7th schedule and residuary powers to ensure that state has autonomy when it comes to the adjudication of physical federalism in India. Now, moving on to Sharkarya Commission, it was constituted by the Ministry of Home Affairs in 1983, and one of the major contributions that this commission has done is with regards to the cooperative federalism concept. Now, we all know that cooperative federalism and comparative federalism coexist in a territory of where federalism is practiced. So, in a democratic country, there is both cooperative federalism and comparative federalism. But whether...
Ma'am, you have 1 minute to wrap up your presentation.
Yes, okay, thank you. Whether competitive federalism should exist more than cooperative federalism is the real question. With India's consideration, like the physical landscape of India, we should note that cooperative federalism should exist so that the states possess the equal autonomy as much as the central government, to ensure that the principle of equity when it comes to physical federalism is employed. Now, when we talk about Finance Commission, it is very, very important in this topic, because because the Finance Commission is enlisted under Article 280, and one of the main duties is that it decides and provides recommendations on how tax should be devolved. Tax devolution is a very important concept when we come to the of fiscal federalism, and tax devolutions recommendations are being made by the Finance Commission. We have to look at the 14th and 15th Commission's report, where in the 14th Commission's report, the tax devolution rate was increased from 32% to 42%. This was done because the spendings of the states in total of India was 60% compared to the revenue that they get, which was less than 40%. Taking this into the consideration, the 14th Commission has increased the tax devolution rates from the central to the state. Yes, ma'am. Yes, ma'am. Next slide, please. Next slide. Oh. Yes. Can you just move? Excuse me. Can you just move? Yes. Yeah. Last. Okay. Now, when we talk about physical federalism, we also have to take note of the FRBM Act, which works with the Constitution of India to ensure that physical federalism is intact. But there are lacunas. As we told, the main lacuna in India's physical federalism is the horizontal imbalance and the vertical imbalance. There has to be measures taken to justify the tax devolution done by the state, by the center to the state, also with regards to cess and surrage, so that the resources, that the financial resources of the state are equal to the development that is being expected from the center, from the state. Now, the center expects the state to develop at a rate, but that should be compensated by giving them equal resources to make sure that the infrastructure is being developed. Now, some of the recommendations according to this, ma'am, just a minute. Ma'am, just one recommendation, ma'am. The main recommendation or the call of action in this research paper would be, can you go on to the next slide? Measures to review off-budget borrowing, that is foreign loans. So the center has to ensure that they review the off-budget borrowing and make the hidden liabilities disappear. And also they have to use economic and social indicators such as per capita income and HDI to distribute and allocate funds from center to state, so that the principle of equity is being followed when we talk about tax devolution and physical federalism. Thank you, ma'am.
When you are talking about federalism, what was the minds of the makers of the Constitution?
Ma'am, the concept of federalism was from the Canadian Constitution. Now, we all know that India is a bag of when we talk about Constitution. So this concept was adopted from the Canadian Constitution because the makers of the Constitution or the Constituent Assembly wanted to make sure that there is a proper division and decentralization of power between the center and the state. This was because when we take a look back at the colonial state, there was provinces, and these provinces differed entirely. When we compare the Calcutta province and the Madras province, the amount of resources and the people, everything differed. So this was kept in the mind when the constitution was drafted, and that was the reason why they wanted to incorporate this concept of federalism. But with this in mind, it was also noted that the imbalance should be imbalances should be somewhat managed by the center, therefore giving them the residuary powers in the constitution to keep the sovereignty intact, ma'am. Thank you, ma'am.
Your presentation was very good, and I have time to go through your paper also. And you had done a very good work actually on the paper.
Thank you, ma'am.
More like a research paper. Try to publish this paper.
Sure, ma'am.
Okay, that's one thing. Another small point to take note of is when there are two presenters, and you know the time limit. 5 minutes was given to you or 7 minutes? 5 minutes. 5 minutes. See that both of you present. He cannot be standing like that. No, because both of you have written it jointly. Both of you must be having equal time to present.
Sure.
Okay, that is one aspect of it. You were very strongly telling it is quasi-federal. True, I agree it is quasi-federal. But some features are unitary, some features are federal.
Yes,
When you come to citizenship, it is unitary. But when it comes to physical federalism, you're talking about.
Ma'am, when we talk about physical federalism, it is not entirely federalism as of now, ma'am, because as I mentioned in my presentation, there exist both competitive federalism and aspects of cooperative federalism. Now, the center has to review the provisions with regards to physical federalism and employ cooperative federalism more than competitive federalism. For example, ma'am, Uttar Pradesh, a state which is one of the largest state, but it is also the poorer state in India because it does not have the physical resources. Now, let's say this state competes with Kerala to get the equal amount of tax devolution from the center. It would not be just. Because the population of Kerala is relatively less, the land scope of Kerala is relatively less, and it boasts factors such as literacy rate, which is more than compared to that of Uttar Pradesh. So this is why there needs to be the approach of cooperative federalism rather than competitive
Ultimately,
federalism.
it is federal features.
Yes, ma'am.
That's it. Thank you.
Thank you, ma'am.
Thank you.
Thank you so much. Now I request Dr. Shaji Sivan to present his paper on the title Right to Borrow, Latest Trends and Challenges Faced by States, a critical analysis of ceiling limits imposed on the state of Kerala.
Respected Chair and dear friends, a warm good morning to all. Myself, Dr. Sajishwan, Associate Professor with Veti School of Law. So today, first of all, I extend my gratitude to Crescent School of Law for providing an opportunity to present my thoughts before you. So today I am talking about the concept which was mooted lastly between the central and state before the Supreme Court. And first of all, the Supreme Court also, in the first stage, if we saw the Supreme Court also reluctant to admit the case, later they are compelled to make a decision on that subject, which is closely related with this fiscal federalism. So here my title is Right to Borrow. So here, what are the trends and challenges faced by the states? Critical analysis on the ceiling limit imposed over Kerala by the central government. Okay. So, last few years, the central has imposed certain economic measures through which they regulate the state as well as they want to reduce the borrowing limit within the state as well as in the central level. So they have introduced a new statute known as Fiscal Regulation and Budget Management Act of 2003, through which they want to regulate the debt within the state and central. So they prescribe that it should not go beyond 60%. And here I'm directly moving to the matters which disputed between the state of Kerala and central government due to the restraint of time. So here, in 2023, the central government taken action against the Kerala state while they are asking permission for borrowing more fund for its development. They issue a notice where they're making a ceiling limit to Kerala to borrowing loan from the India as well as from the foreign countries. So while we see the constitutional provision as to the borrowing rights, it's mentioned under Article 292 and 293 of the Constitution, where 292 give an enormous power to the central to raise fund through loan or other aspects. As with regard to Article 93, it's a restrictive in nature, where it through Article 93 293 it provides that the through some regulation, the state government can borrow loan from other institution. And here, what was the questions or what was the limitations which provided under Article 293? So, state can borrow from India with certain regulation as to their consolidate fund. Secondly, the state can borrow money from the central government or from any other institution with the permission of the central government. So, it is the central government act as a regulatory institution while they are borrowing the fund from any other institute, as well as if they want to raise any fund from the foreign countries, they have to get the permission from the central government. So, these are the concepts which provided under Article 293 of the Constitution. So, as we have discussed the facts, where the central government sent a notice to the Kerala state government stating that you are sealed, you are not able to take the loan from any other institution because the year 24-23 you are exceeding the limit which fixed by the statute. So, here the state government moved a writ petition under Article 136 before the Supreme Court, where the concept were discussed, what extent the state can borrow under Article 23. And secondly, the concept is whether the public fund as well as consolidated fund can be considered as together while making the ceiling limit as to borrowing. And thirdly, what extent the judicial spirit is vested under Article 293 of the Constitution, where the Kerala state gave their representation in different form, and they are stating that the borrowing a state also fall under the entry, follow under Article 226 clause 2, which is where the public account is considered as a separate entity as well as the consolidated fund is in a separate one, so which cannot be clubbed together for while they are making the finance overall turnover in the finance year. And secondly, with regard to the amendment made in 2018 with related to the imposing of ceiling limit as well as the inclusion of the state's right to borrow under entry 43 of the state lit. So, yeah, yes, sure, ma'am. So, while deciding, while we are looking to the judgment, the Supreme Court clearly states that they are admitting the submission made by the central government, denying the statement made by the state, and state that while the state is borrowing the money, they have to follow the rules and regulations set up by Article 293 as well as the Fiscal Regulation and Budget Management of 2023. From this, we can conclude that the states are, through this decision, they are giving a warning to the state as well as they are protecting the interest of the federalism, that the state should be utilize their resources, and when they are borrowing the money, they must ensure that they are following the instruction as well as the direction given by the central government. Thank you, ma'am.
FRBM Act, so there's a 60% ceiling.
Yes, ma'am.
Right, sir? Do you think that is sufficient? It should be enhanced or decreased?
Ma'am,
Because
actually,
data related to any other, because Kerala touches the ceiling. It goes above, so it is restricted. What about other states where they borrow less than?
ma'am, as the earlier presented, as the statement made by the earlier president, it depends upon the geographical and the population and their resources. It depends upon all the factors. According to that, only they can borrow the amount, because
Do you think that Kerala needs enhancement of the ceiling limit?
Because it has got so much of natural resources, to the peak it does not, and it can develop its own
The-
tourism. It has already developed its own tourism and other resources also.
yes, ma'am.
Why is it depending so much on center when it has got already 60%?
Ma'am, the answer is also there, because with related to Kerala, they are raising the fund within only certain limited resources. It is not extended to that limit, but because the industries are very,
Foreign revenue generation.
yeah.
Also very great. It's good, right?
It's good, ma'am, but
Revenue also.
it's good, but during the COVID time when the state start to raise the,
That is an exceptional situation which you cannot raise it generally. Na?
yeah, ma'am.
See, as
But when
President was telling, UP is a big state,
Hmm.
Kerala is a small state. But the resources here are plentiful compared to bigger states.
yeah, ma'am.
It has come to the ceiling limit, maximum ceiling limit. So,
But the only object behind this fiscal regulation and management, budget management act is to minimize the national debt. So for that only they are in.
Because I think we are running out of time. Mansa ma'am, please. Thank you ma'am. Mansa ma'am is the right person to add on.
your paper is good, confined to state of Kerala, but it would have been better if you had made some comparative study with other states in India.
Okay, ma'am.
Some slight improvement would have been done, especially your all points would be highlighted when you compare it with other states in India.
Okay, thank you.
Thank you so much, sir. Now I call Miss Ashima.
Yes, due to lack of time, because we have got a panel discussion which will be going on soon. So, yeah, please restrict yourself.
Good morning, everyone. My name is Ashima. I'm a research scholar of the National University of Advanced Legal Studies, Cochin. I'm here to present our research on borrowing powers and financial relationships, analyzing the dynamics between center and states in India. So I worked on this with my co-author, Mr. Babu Bitovan, and today I will take you through the findings, the key aspects of our findings. So basically, I'll be discussing the borrowing powers of the states generally and the regulatory framework in India and the challenges it creates for the center-state relations. So as we begin with, it is important to look into the the bigger picture. So across the world, there has been a noticeable trend towards decentralization with the subnational governments interested with greater responsibilities. However, there emerges a common challenge, that is insufficient revenues needed for financing these greater responsibilities. So this challenge forces the states to rely more on borrowing. Yet globally, this borrowing, like subnational borrowing, is not universally granted. For example, in Denmark, it has been prohibited altogether, and in federal countries like India, it has been restricted. So even though these are restricted, it is clear that the nations are increasingly understanding the efficiency and the equity benefits that the subnational borrowing gives, and therefore it allows under specific frameworks. So next slide. The advocates of borrowing, subnational borrowing, argue that it has many benefits. So I'm not going deeply into it because of the time constraints, so I'll just read it out. So it says it allows to access additional finances so that they can invest in infrastructure, and then it will help in efficient and intergenerationally equitable financing, because all the costs of long-term projects, it will help to spread it over time, and then it helps in fiscal transparency of the states, and then development of national financial markets. Now, so as we saw, there are so many benefits, but it is important to manage it properly in order to minimize the fiscal imbalances. So this is where the regulatory mechanisms step in. So we can divide the regulatory mechanism, regulatory regulations into two: ex-ante regulations and ex-post regulations. Ex-ante regulations are proactive in nature. They establish control over the borrowing before the government engages in, and then comes the ex-post regulation. It is actually it helps in addressing the consequences of non-compliance of these fiscal rules and also any kind of imprudent behaviors. So every time there should be a balanced approach that integrates both ex-ante and ex-post regulations in order to maintain a fiscal discipline. Next slide, please. Okay, moving on to the the concept of subnational borrowing in India. So we have India has many unique frameworks rooted in constitutional provisions, fiscal responsibility legislations, and other institutions like Finance Commission and RBI. So Article 293. Article 293 is the provision that deals with the borrowing powers of the states. It says that states can extend their borrowing within the territory of India, and then they need consent to borrow further if there is any outstanding loan. And also, while giving the consent, the center can impose conditions. So it gives more flexibility to the. It gives a unfettered power to the center to impose conditions, because it is qualified by the term those conditions as it thinks fit to impose. And then comes the role of fiscal responsibility legislations. Fiscal responsibility legislations, there is a central act called Fiscal Responsibility and Budget Management Act 2003. It has brought in certain limitations over the borrowing powers. So it says that the central government they shall endeavor to ensure that the limitations are intact. So that means that there is an impression like they are expected to make reasonable reasonable effort to meet those objectives, but it is not mandatory for them. Still, there is an opportunity for the central government to influence the.
Ma'am, you have 1 more minute to wrap up your
finances
presentation.
Thank you. Finances of the state. And then comes the role of finance commissions. As we know, finance commission also prescribe certain borrowing limits. Their recommendations are not self-executory or binding over the governments. Still, there is a convention that convention has been developed that their recommendations, the central government adhere to their recommendations. And then RBI of India, Reserve Bank of India, they also collaborate with the central government in fixing the borrowing limits. Next slide. Moving on to the current developments in this area and the impact of these regulations over the center-state relations. So it is crucial that there should be central supervision over these state borrowings, because each states have their own power, their own capabilities, or it will be difficult if they start borrowing independently in order to monitor their debts and all. However, it impacts the fiscal operations of the states also. So there is an apprehension of centralization, fiscal centralization, and the states often contend that their ability to independently manage their finances is lost. And also, as we saw in the previous regulations, the central influence is very high. So. Sorry, sir, the last.
Yeah, with respect to revenue.
Okay.
Revenue.
Okay.
Through revenue only.
Okay.
Yeah, through expenditures only.
Okay.
How we will overcome with this fiscal deficit?
Sir, I would say cooperative federalism is the key, because there should be always a collaboration between the center and state. So each of the states have their unique fights, their struggles. So center should collaborate with them and come up with new framework like regulatory measures, and it should increase their grants to the states, and by like encouraging them to more economic. Thank you so much.
Thank you so much. Now I call Ms. P. Nityashri and Mr. C. Kotekali to present their paper on the topic, the role of the Planning Commission in India and NITI Aayog.
First of all, good morning you all and my respected judges and my colleagues. First of all, I introduce myself. I am Nityashri from Chennai Dr. Ambedkar Government Law College, Pudupakkam. Today, I present with the role of Planning Commission and NITI Aayog in India. After the independence of India, the government faced a high financial struggles, and the situation seems like newborn baby. So, the former Prime Minister Motilal Jawaharlal Nehru introducing the Planning Commission in 1950 to formulate economic policies and beginning a welfare state. When the first plan was implemented after the inception of the planning commissions, the primary focus was given to the agriculture sector of the country. The planning commission struggled a lot with the implementations and forming because of various reasons. Besides, that regulating of the commissions was broken when there were annual plans implanted at the place of 5 years plans. The planning commission was dissolved in the year 2014 by the current Prime Minister Narendra Modi. The NITI Aayog, established in 2015, is an Indian democracy's youngest institution. It has been ensured with the mandate of reimagining development agenda by dismantling old style of the system. As the Indian economic rapidly increased with the global economic constitution associated between central planning and increasing private capital flows, the NITI Aayog was mandated to federal cooperative federalism evolve a national consumes. NITI Aayog plays key role continuing the state and union territory, but some other states are also against NITI Aayog. So, NITI Aayog wants more power and implicate. To be continued, my co-author.
Okay, good morning to all my respective judges and colleagues. Now I explain achievements in NITI Aayog. NITI Aayog has made significant strides in driving India's development agenda with notable achievements across various sectors. Its 3-year action agenda and 15-year vision document provide a roadmap for India's growth, while the SDG index tracks progress on global goals. The composite water management index and healthy states Progressive India report enhance water management and health outcomes. Partnership with the UN and initiatives like the Women Entrepreneurship Platform.
Excuse me, ma. If you want hand mic so that you will be visible. Yeah.
No, ma'am.
You are comfortable there? Oh,
Please come this side now. You can use the hand mic. We can't see you.
shall I give the hand mic?
Partnership with the UN and entrepreneurs like the Women Entrepreneurship Platform demonstrate NITI Aayog's commitment to collaborative and inclusive development. Through these efforts, NITI Aayog is shaping India's future, addressing complex challenges and improving lives through data-driven policy innovation. And now explanation to future plans of NITI Aayog. Developing a shared vision of national development priorities, sectors and strategies with active involvement from the states. Fostering collaborative federalism through structured support initiatives and mechanism with the states on a continuous basis. Ensuring that all sections of society benefit from economic progress. Protecting the environment while promoting economic growth. Leveraging technology to improve governance and development. Now I am going to with the conclusion. In conclusion, this study has examined the evaluation of development planning in India from the Planning Commission to NITI Aayog. The findings suggest that while both institutions have strength and weakness, NITI Aayog's decentralized data-driven and private sector engaged approach has the potential to drive more inclusive and sustainable development outcomes. Thank you, ma'am. Thank you, ma'am. Yes, ma'am. 7 pillars, importance of 7 pillars: constitutional integrity, innovation, inclusion, and federalism of sustainable development, and governance of reforms and governance, ma'am. Yes, ma'am.
Been working for quite 9 years now. 9 years
Yes,
now.
ma'am.
And there are no other lackeys at all.
Need,
Should be balanced paper.
yes, ma'am. Thank you.
Thank you.
Thank you so much. Now I call Mr. C. Lakshmanan to present his paper on the title, The Role of the Finance Commission in the Distribution of Taxes Between the Union and the States.
Good morning to all. I really thanks to Crescent Law School to give this opportunity to present this paper. I really thanks to Ma'am Anuradha Ma'am and Vijayalakshmi Ma'am. Thank you Ma'am. Thank you very much. My topic is the role of the Finance Commission in the distribution of taxes between the Union and the states. The Finance Commission is a pivotal constitutional entity tasked with the recommending the equitable distribution of financial resources to uphold the fiscal equilibrium with the federal frameworks. The Finance Commission role in the allocation of tax revenues between the Union and the states, governments in India emphasizing the recent budgetary and legal advancements. Under Article 280, the Indian Constitution, the Finance Commission is a pivotal constitutional entity. I repeatedly stating that the constitutional entity, it has a more power to recommend the government to implement the tax dividends. Recently, particularly at the time of COVID-19 pandemic, has exerted immense pressure on Indian federal fiscal structure. The pandemic caused significant contraction in economic output, leading to reduced tax revenues for both the Union and states. This situation aggravated existing vertical fiscal imbalances as states already dependent on transfer from the Union faced soaring expenditure in healthcare, social security and infrastructure development. The Commission introduced a national state disaster risk mitigation fund to improve preparedness for disaster. Vertical fiscal imbalance. Vertical imbalance arise from the mismatch between the revenue raising powers of states and expenditure responsibilities. At the same time, horizontal fiscal imbalance refers to disparity revenue generating capacities in public service needs among states. The Finance Commission role in managing fiscal federalism, the pandemic triggered an actual fiscal stress on subnational governments, forcing states to grapple with significant revenue shortfalls while facing surging expenditure demands, particularly in the healthcare, social security, and disaster management sectors. At the same, the introduction of the GST, Goods and Services Tax, in 2017 also represents a fundamental change in union state revenue sharing frameworks. GST consolidated the range of state and central taxes into a single tax regime, simplifying tax administration and eliminating barriers to interstate commerce. In conclusion, the 15th Finance Commission has made significant efforts to address the fiscal challenges posed by the evolving economic landscape, structural issues such as the growing uses of cess and surcharges, the impact of GST, and constrain the state borrowing, continue to improve the realization of equitable, sustainable fiscal federalism in India. In Canadian government, model primarily adjusts the transfers based on revenue generating differences, without occurring for expenditure needs. Reforms to the GST framework, such as enhancing its progressively and nationalizing exemptions, could help ensure that it remains robust source of revenue for both the union and the states. In Australia, GST-based equalization model, which accounts for both revenue capacity and expenditure needs, ensure the states with lower fiscal capacities receiving adequate support. Finally, the conclusion, while the Finance Commission plays a crucial role in India's federal financial structures, the current revenue sharing models require to enhance their predictability, transparency, and effectiveness. Addressing the challenges posed by cess, surcharge, GST distribution, and property tax reforms is critical for maintaining fiscal balance in a rapidly changing economic environment. Thank you very much, madam. Thank you.
Thank you so much, sir. Now I call Mr. Hassan and Ms. Tahira Mirza to present their paper on the title, The Role of Artificial Intelligence in Strengthening Intergovernmental Fiscal Relations, a Comparative Study.
Request, you have to be very crisp and short and continue. Right? We don't have the time. For the rest of the people, please bear with us. You have to be very crisp and you have to be very short.
Good morning, everyone. Myself Hassan, the author, and this is Tahira Mirza, co-author with we are from Current School of Law. Today we are going to present the rapidly evolving topic, role of artificial intelligence strengthening the intergovernmental fiscal relationship, a comparative study. Artificial intelligence is already transforming many sectors from the e-governance to the digital transaction. AI has become a key player everywhere. This got a thinking, why not applying this AA principle to the physical relation? That's where we started as a explore this idea. We found some countries like France, Brazil, and Indonesia that has already successfully integrated AI into this physical management. So, how can AI improve financial management? By automating tasks, by automating resource allocation, and by informed decision. For instance, if the 18% of GST is collected in Tamil Nadu, AA can help ensure the allocation happens smoothly and automatically between the state and central government, removing the need for the bureaucratic delays. AI also plays a crucial role in the fraud reduction. By analyzing past trends, AI can improve budgeting and forecasting. It also monitors financial transactions, flag suspicious activities, and prevent fraud, ensuring public funds are used responsibly. Let's look at how some other countries have done it. Take Indonesia for example. Their Ministry of Finance have developed an AI system called IFA, which standardizes municipal budget and financial reporting. IFA uses real-time data from municipal budget and performance report to monitor the economical health of the local government. This helps center authorities identify risk early and respond with the better informed policies. It also helps local government manage their finance more effectively. Now the following slide will be presented by Taira.
Greetings everyone. Let's get a glimpse of case studies of other countries that have effectively integrated AI into fiscal management. So let's start with France. In France, the Public Finance Directorate is using AI to monitor local government finances. They have developed an early warning system that can flag local authorities who might be heading towards financial trouble. This way, the government can step in before small issues turn into a big problem, keeping finances stable. In Brazil, AI being used in a different way. They have a system called Allies, which looks at the public procurement processes. Allies scan contracts to find risky ones, allowing auditor to focus on those that need most attention. This helps reduce corruption and ensures that public funds are spent wisely. The OECD is also experimenting with AI through a chatbot called Fiscal Federalism Advisor. This chatbot is powered by advanced technology like GPT, which can analyze a huge amount of data to give real-time policy advice. It helps government make better decisions by providing insights quickly and efficiently. So each country is using AI in a unique way, whether it's to prevent financial crisis, oversee public spending, or assist in decision making. But the goal is the same, to make fiscal management smarter and more efficient. Next, please. So what does this mean for India? AI has the potential to transform India's fiscal system, especially when it comes to tax administration. In fact, we are already seeing AI being used in a task like tax calculation through GST network, which is a good start. However, as we continue to integrate AI more deeply into our financial system, it is crucial that we make sure it fits within the India's legal framework and respect the principles of federalism. One major concern we need to address is privacy. Around the world, laws like GDPR in Europe, FTC regulation in US, and CCPA in California are in place to protect people's data. Similarly, India has to focus on creating strong regulations like the Personal Data Protection Bill and the Information Technology Act to make sure our citizen data is safe as we adopt AI widely. Next slide, please. Lastly, there's an important question that may arise among you. Should AI have the final say in fiscal decision? In our view, AI should never have the final say. Human oversight ensures that decisions are ethical and grounded in broader social and political considerations, which AI may not fully understand. The balance between AI and human judgment is the key to build public trust. Ma'am, sir, kindly take note that we do not intend to replace human with AI. Rather, what we suggest is we can use AI as a medium tool to simplify humans' work. So with this, to conclude, AI offers an incredible opportunity to make fiscal management more efficient, transparent, and accurate. By automating tasks, improving resource allocation, and helping make better decisions, AI can bridge the gap between central and state government. Thank you for your time and attention. Looking forward for the questions. One second, ma'am. Yes, ma'am. Ma'am, we included this case law because it talks about federalism, fiscal federalism. Ma'am, since we are talking about fiscal federalism, we thought, okay, why don't we just include a case law to stand this thing? But it is not related to AI. Yeah, not AI. Yeah. Okay, thank you. Thank you.
Because you say you don't want to, but if you are continuously using it, AI might replace
That's why
in all the fields, not
no,
just in
no, ma'am. Humans are the one who creates AI. So AI won't replace human.
there might be a situation where AI will.
That's why human experts are there. They can't let the AI to replace human.
Thank you so much. Great job. Yeah, yes. It was a different.
Thank you so much. Now I call Mr. Varun Prakash and Mr. Venkata Krishnan to present their paper on the title An Analysis of Financial Emergency Provisions in the Indian Constitution and Their Impact on the Autonomy of the States.
A very good morning to the respectful judges and our one and all present here. I am Venkata Krishnan, second year BBA LLB from Crescent School of Law, and I am the co-author of the research. We are here to present our research paper on the topic, an analysis of the financial emergency provisions in the Indian Constitution and its impact on the autonomy of the states. Now I would like to call on Mr. Varun Prakash, the author of the research, to resume the presentation.
Happy morning, everyone. I'm Varun Prakash from Crescent School of Law. Before getting into the topic, I would like to say why we have to care about financial emergency when it has been never invoked for the past 78 years since independence. I think that it is a need to reflect its significance in the complex issues we are facing today. The economies around the world have been facing a lot of economic aggressions, like, for example, global recessions, pandemics, or financial implications across the world. And the countries are very vulnerable to its causes. For example, to say this, for Sri Lanka or Argentina are the recent examples of economic collapse. India is not immune to these shocks. So it is essential to know what financial emergency is. So for this instance, if we have to say what financial emergency is, we can say that a financial emergency is a legal framework or a provision which exists to safeguard the national economic security when it faces a jeopardy. So for that instance, next slide please. Next. It is defined under Article 360 of the Indian Constitution, and it is basically a safeguard for the national economic security for that instance. Next slide. According to Austin, under Article 360 of the Indian Constitution, a financial emergency can be declared if Indian financial stability is in jeopardy. This provision grants the central government sweeping powers, including the ability to cut government salaries and require state finances and require state finances to align with national priorities. While it has never been invoked, the mere existence of such a clause underscores the importance of safeguarding the national economic foundations. Next slide, please. So when the financial emergency is invoked by the president, if he feels so, he needs to get the approval from the both houses of the parliament, and after that, the first thing that is going to happen is the budgetary control. The central government or the union government gets the power to frame policies that the states has to follow when they are facing a financial adversity. And the next one is the salaries of the government official, including that of the judicial officers like the High Court judges and the Supreme Court judges, also has to, the reduction of salaries should be there. And after that, the taxation powers. The union government can take the taxation powers by itself to revive the economy. And after that, we have borrowing powers, which will be controlled by the central government or restricted by the central government during the financial emergency. And the judicial oversight, which is very important in our case. The judicial review, which is always there, will be limited due to the financial emergency. But the real issue I'm here to speak is not about the financial emergency that is going to invoke. Just imagine that the financial emergency invoked for the next 2 years. What is going to happen after that? What is the impact we are going to face after that financial emergency? The real thing about that is the fiscal federalism, which is some sort of a framework, will get eroded due to this decision-making ability or the overpowering of the union government. We have already faced this in the past, like the 1975 emergency. But the real thing is, in my opinion, I really want to say that the government should form an higher committee so that we...
So your time is up.
So I have to say that the government may form a higher committee so that we are not facing the same adversity as of the 1975 emergency. And I have to say, let us hope that this research paper acts as a stepping stone for a better tomorrow. Ma'am, I think so. I'm not foreseeing it in the way that... No, ma'am. In that context, we can't really predict the world's global... no, ma'am. I'm saying it in a way that the world is in a very unpredictable way now. Even the most stable economies, even the world's most stable economies are facing volatile situations or precarious situations due to currency volatility or something like that. So we can't really predict what happens now. Yes, ma'am. Yes, ma'am. Second year, ma'am.
You're yet to learn constitution,
Yes, ma'am.
right?
Maybe as madam was telling,
Yes,
they want a mic, they were telling me they want a mic to be used. Maybe as madam was telling, it might be a brainchild, but see that there is some connectivity between the topic that you are presenting and the topic. It is too far-fetched. So many hypothetical situations you have brought in. Please
I just want to say about the...
A good presentation, but very hypothetical. Look over once again.
Okay, thank you, ma'am. Thank you.
Thank you so much. Now I call Ms. Brindu and Ms. Taskeen to present.
Please continue presenting papers. Don't get rejected. Please continue presenting papers. Only then you will learn. Good job.
Ms. Taskeen to present her paper on the title Evolution of Indian Constitution, Historical and Comparative on Fiscal Federalism.
A very good morning to one and all present here. I am Taskeen, 5th year Crescent School of Law, and the topic of my paper is Evolution of Indian Constitution, Historical and Comparative Perspective on Fiscal Federalism. When we hear the term fiscal federalism, the first question which arises in our mind is what is fiscal federalism? Fiscal federalism refers to how federal, state and local governments share funding and administrative responsibilities within India's federal system. However, there are certain key components to the term fiscal federalism. First one is the revenue collection, that is taxes and the duties which are imposed. Second thing is the expenditure responsibilities, that is the infrastructure of the country or the public services. Third is the transfers and grants. So when we talk about transfers and grants, it refers to those imbalances such as vertical imbalances or horizontal imbalances, which can be resolved through a variety of transfer and borrowing mechanisms in order to allow the various levels of government to perform their allocated tasks within a national policy framework. Next slide. So this is an overview of the topics I'm going to be dealing with in my paper. Next slide. So let me give a brief introduction to fiscal federalism in India. Fiscal federalism was not an indigenous thought process, but to a great extent, it had been derived from a colonial governance. Primarily, it was influenced by the British rule. So there was a gradual evolution from a centralized system to a decentralized one. Next slide. So when we talk about the evolution of fiscal federalism in India, we can broadly divide it into 5 important phases. First one is the conceptualizing decentralization of finances, which took place from 1858 to 1871. So in this phase, there was rigid centralization with minimal financial powers for provinces. Second one is the informal decentralization of finances, which took place from 1871 to 1919. The third phase, there was a formal decentralization from 1919 to 1935, in which the Government of India Act of 1919 had formalized the decentralized financial governments, and there was also a separate budget which was introduced for central and provincial government.
Fourth one is the decentralization to federal finances. And fifth one is the starting of constitutional fiscal federalism. So in this, the Constitution of India had adopted a modified version of Government of India Act 1935 Financial Provisions. And as we all know, the Finance Commission is created to manage revenue distribution. Next slide. So next slide deals with the evolution. When we talk about the evolution, let's take a look at the background. So after the British control started during 1858, there was a strict centralization of finances. Further, there was a recommendation which was given by Samuel Lang, who was the first person to propose to grant some financial powers, including taxation powers to the provinces. Carl Strachey, who had introduced the Strachey scheme, had introduced roads, jails, education, and medical services should be transferred to provinces. So 1/6 of the land revenue and 1/4 of proceeds of license taxes should be allocated to the provinces. Next slide. Informal decentralization, which took place from 1871 to 1990, the major act in this informal decentralization was the Lord Mayor's decentralization, which took place in 1870. So they started to formalize decentralization. And so if we take a look at the post-independence fiscal federalism, that is from 1947 to 1950, there was a Constituent Assembly where they had retained the framework of Government of India Act 1935 with certain modifications. So the key reform over here was the establishment of Finance Commission, that is Article 280, and it was established in order to oversee the distribution of revenue between center and states. And there was also a major recommendation that included the 40:60 split of income tax between center and states. So the role of Finance Commission, the purpose of Finance Commission was to recommend how central revenues should be shared with states. And the first Finance Commission, which was established in 1951, set the foundation for balancing financial needs between center and state. The ongoing role right now is that every 5 years, the Commission assesses and makes recommendation on fiscal transfer and state funding. So the key issues in Indian fiscal federalism as of now is the vertical imbalance and the horizontal imbalance. When we talk about vertical imbalance, the center has more revenue raising powers, while state, it has more expenditure responsibilities. And when we talk about the horizontal imbalance, the disparities among states in terms of revenue generating capacity and development levels. So what are the revenue for these issues? One is the intergovernmental transfer, that's the grants and loans, and the second one is the centrally sponsored schemes for targeted development in poorer states. So when we deal with the contemporary challenges, there were 3 major contemporary challenges. First one was the GST implementation, which took place in 2019. So this was a unified taxation system which replaced various state and central taxes. But the major issue which was concerned over here...
You have 1 minute to wrap up your presentation.
Yes. But the major issue which was concerned over here was about the state's financial autonomy. And the second one was increased dependence. So the states, they rely more on central transfers post-GST, challenging the balance of fiscal power. And the third thing was the COVID-19 impact. So this aggravated fiscal stress on states, and they highlighted the need for flexible fiscal federalism. Next slide. So in conclusion, fiscal federalism in India, it has evolved from a highly centralized system under British rule to a more balanced but still centrally dominant system. And the Finance Commission, it plays a crucial role ensuring a balanced distribution of revenue. The ongoing reforms and challenges such as GST, they require adapting to fiscal federal structure to meet contemporary needs. And the Indian Constitution, they retain strong central control over financial matters but allowed provinces with some financial autonomy. Thank you.
You have given more of importance to the evolution part of it.
Yes, ma'am, that's my topic.
But being in the 5th year,
yes,
some innovative thoughts must have come for this paper. Something better where you could have, see, it's a more generalized paper. Don't think otherwise. Better standards were expected from a 5th year. Don't think otherwise.
Okay.
Thank you.
Thank you.
Thank you so much. Now I call Ms. Ananya and Ms. Archana to present their paper on the title, The Journey from Revenue Sharing to Corporate Governance.
Very good morning to one and all present here. I am Ananya from second year BBA LLB from Crescent School of Law. This is Archana from second year BBA LLB, Crescent School of Law. We are here to present on the topic Fiscal Federalism in India, a journey from revenue sharing to cooperative governance. Fiscal federalism, let me give you a brief introduction about the topic. It is the financial responsibility between the different levels of government and also the shared funding and administrative responsibilities. Fiscal federalism, let us see from the evolving system. It is evolved from the revenue sharing to cooperative governance since the independence from 1947. Constitutional framework, the division of fiscal powers had happened between the union and the states. The financial needs are accommodating the growing financial needs of both the national and the regional government. Many landmark reforms have been made in the economic liberalization in the 1990s, and also the introduction of the GST, the goods and service taxes, in the 2017 have been significant. Importance of the fiscal federalism, that is the understanding of India's federal structure. The India's federal structure defines the dynamic relationship between the central governments and the state government. Fiscal policy and government, it focuses on the regional development, economic growth and national duty. Cooperative governance and GST has its implications for cooperative federalism and fiscal relations. The fiscal equity and regional disparities have contributed to the distribution of resources across India's diverse states. Over to Archana.
Literature reviews. Evolution of Fiscal Federalism by Govind Rao and Nirvika Singh. Balancing Centralization and State Autonomy by Amaresh Bachi. Cooperative Federalism by Nirvika Singh and Rutra Bhattacharya, and Challenging of Fiscal Federalism by Kiran Bhatia. Theoretical framework. Fiscal federalism, the study of division, government function and financial relationship between the different levels of government. Key concept is the responsibility between the different levels of government and revenue sharing model. It provides a theoretical support for revenue sharing and correct vertical imbalances to ensure the funding and public service. Over to Ananya.
So as we see, evolution of fiscal federalism in India started from the colonial framework pre-1935, which led to the federalism initiation in 1935 with a clear division of powers between central and state provinces. It led to the post-independence era, which came with a strong center with residual powers in 1947 to 1950. The finance commissions also led to the equitable distribution of resources, which came with the economic planning from 1950s to 1980s. About the fiscal federalism. Ma'am, from the beginning, fiscal federalism has facilitated in focusing the division between the state and the central government. So it has given rise to many opportunities and also challenges. Now, since we follow the cooperative federalism, the cooperative federalism has helped more in achieving goals faster, is my opinion. When the centralization led to the focus on central government and the state government, so the powers were separated and the state government was not given more opportunities maybe. Thank you.
Thank you so much. Now I call Ms. Saranya K. to present her paper on the title Local Government Finances, Devolution Issues and Reforms.
Good morning, one and all present here. My special greetings to the panel members. Myself, Saranya. I am from Tamil Nadu, Dr. Ambedkar Law University. I am pursuing LLM Taxation first year. My topic, Local Government Finances, Devolutions, Issues and Reforms. So the paper, it aims to examine the local self-government's financial status in India. So the local governments, they are categorized into rural local bodies and urban local bodies. Rural local bodies are Panchayat Raj institutions and urban local bodies are municipalities and municipal corporations. So these institutions can perform effectively only if the required fiscal, political and administrative autonomy are given to them. So
this paper inculcates to critically analyze the fiscal decentralization, devolution and the autonomy of these local self-governing institutions, and whether there is an imbalance between the expenditure responsibilities and the revenue raising powers, which is ultimately due to the issue of the local taxes, the prevailing political compulsion and the issues in equalization. Next, the fiscal decentralization in India. Starting from the recommendations of Balwantrai Mehta Committee to the P.K. Tungan Committee, they played a pivotal role for the evolution of 73rd and 74th Constitutional Amendment Act, which ultimately confers the powers and authority to the PRI to function as a self-governing institutions, enacting Part 9, 9A from Article 243 to 243 OW, important taxing powers. And then dealing upon the sources of these institutions. So they are mainly dependent upon the own tax revenue, non-tax revenues and the grants from the central finance commissions and the state finance commissions devolutions. But mainly they are dominated by the grant in aids that are rewarded by the central finance commissions. They were a rise in their total revenue from 2020 to 2022, but they were a decline in 2023 mainly due to the decline in the grants rewarded for them by the central finance commissions. So the states, the local governments have always have to look upon the central governments for their grants, and they are always at the mercy of the central government. And next, the internal revenue of the total revenue of the local governments is only 1.1% to 3.3% of their total revenue. Then moving upon to the major issues and complications in the local self-governing finances, primarily in the administrative perspectives and financial perspectives, the available tax resources is substantial, is very meager and very less in revenue generation except the property tax. And the other issue is in collecting these revenues, the PRS is facing issues because it is a limited tax base, and due to inadequate infrastructure and the inadequate quality and qualified employees. And number two, there is no exclusive functional domain of rural and municipal governments even after 73rd and 74th Constitution, because the word may inserted in the Article 243W, it implies the state's absolute prerogative power. That is, there is a large gap between the de jure incorporations and the de facto functions, the functions which are transferred by the state to the municipalities. And number two, there is no exclusive fiscal domain for municipal governments even after 74th Constitutional Amendment, because they possess only legally delegated powers and functions, and not the powers that is general competence powers which state possess. And number three, there are inadequate and ineffective fiscal devolution mechanism. In some states, there are at least partial devolution, but in some other states, there is no devolution happening at all. And moving on to the challenges in functional and financial autonomy of local governments, the first and foremost is there is a necessity
you have 1 minute to wrap up your presentation.
Thank you. There is a necessity for amending the earlier bureaucratic practice in contemporary era, because even after the budget approval, the funds are not made available to the state governments, to the rural governments, due to cash constraints in the state. And number two, there is a need for expansion of horizons, because they need to strike a balance between the responsibilities and the resources. And number two, there is an issue of narrow tax base, which is ultimately compounding by low buoyancy of own taxes. So there is a need for enhancing the own sources of revenue. And the last one is regarding equalizing the interjurisdictional spillovers. That is, intergovernmental transfers should be always based on the rationales of correcting the horizontal and vertical imbalances at the subnational levels. And the future directions and policy measures, in my view, in my perspective, that is, the central government can set up a mechanism to strengthen the intergovernmental economic relations, which will ultimately strengthen the intergovernmental fiscal relations also. And then the yes, ma'am. Schemes, centrally sponsored schemes. Yes, ma'am. That is a yes, ma'am. Yes, ma'am. With your due respect, that is a very problem here because the state governments are running in deficit due to the centrally sponsored schemes. Because irrespective of their revenue sources, they are the centrally sponsored schemes are allocated to be implemented. But there is no adequate funds for the implementation of such schemes. So due to which the local governments are running in deficits, which is a very big issue. Can I conclude, ma'am? Last one word. Yes. So every representations should start at the ground level. So the real representation of people is what is the representation by the ward members, the councillors, and the local authorities. Every plan will remain as a draft plan until it is implemented effectively by these local authorities. So they have to be given fiscal autonomies and autonomy in administration as well. Apart from these issues, may our motherland continue to prosper. Thank you so much for this wonderful opportunity. Thank you, ma'am.
Thank you so much. Now I call Ms. T. Ambika and Ms. S. Joshika to present their paper on the title, A Study of the Problems Faced by the People in Disaster Management.
I request you to be very brief because you couldn't make it yesterday. Yes, ma'am. Yeah, we don't have time. We have to wind up by 11:30.
Okay. Ma'am, can I get a hand mic?
Yeah, sure, sure. Please. One more is there, I think. One more part. One more. Please be very brief so that the crux of the thing. And we go. Thank you.
So good morning to the resource persons and good morning to one and all who present here. This is Joshika from Satyabama School of Law, doing my BA LLB honors third year, and I'm representing myself as a co-author, and my first author, that is author, is Dr. T. Ambika, Assistant Professor, Satyabama School of Law. So we have researched a paper in the topic of a study of the problems faced by the people in the disaster management. The main aim of this paper is to, we have that curiosity to bring why this problem has been arising in order to, when it comes to like disaster management. So, yeah, okay. So we have 5 key elements in order to describe and define what is disaster management is. The first key element is prevention. The next is preparedness, response, recovery, and mitigation. So these 5 elements together, we form the disaster management of definitions. So when it comes to mitigations, the really good example and a crisp example for that would be wear seat belts in order to avoid injuries. So here we are mitigating it. We are mitigating the injuries which is going to be happen in the future. So that is called the mitigation. Then moving on, pre-disaster. So we have segregated the problems into 3 segments, that is pre-disaster problems, pre-disaster problems, during disaster problems, and post-disaster problems. So when it comes to pre-disaster problems, we have lack of awareness, inadequate emergency planning, insufficient resources. This was taken into consideration of pre-disaster problems. So when it comes to disaster, when we are getting the disaster kind of a thing, when it comes to like flooding and all, so we are lack in awareness. When we get the notification of whether we are about to receive the flood, we have to take into consideration and do the needful for ourselves. We cannot rely on the government, because going to the government and telling that no, you're not giving me sufficient this or that and all, we cannot.
Legal issues in the We're talking about all these preparations.
So you want me to give the solutions? Okay. Okay. So if I am in the NDMA, National Disaster Management Authority, if I am in that place, I would have done the solution of train volunteers to monitor flood prone areas. So when it comes to Valedictory and all, there was a huge flood happened and many people got a severe attacks and many people have died due to that particular disaster. Then flood alert apps can be implemented, but without using internets. Without using internets. During disasters, we cannot rely on the internet. We cannot rely on the internet. So we can go with the flood alert apps, then monitor with the drones. I'm not telling drone is not at all sufficient. I'm not telling it. Drone is actually existing in our. Yes, ma'am.
I want you, because being a budding lawyer, so energetic, I want something, what can be done as a legal thing to solve this or to better facilitate? Because it's DM
Yes, ma'am.
and disaster management related thing, how to overcome, how to get fund, how to generate fund, or how will we pool fund?
Okay, ma'am. So when it comes to NGOs, we can get funds from the NGOs. So NGOs is. Yes, ma'am. As a citizens, we can ask help from the NGOs, stating that we are unable to get food or. Yes, ma'am. Yes. Yes, ma'am. So it's like a. So. Yes, ma'am. But to give the solutions, we have brought up some of the solutions as a budding lawyer, as you mentioned. So the solution as said can be implemented in the rural area as well, not to pretend to be in the cities itself, because rural people are not that educated. I'm not telling they are not that educated, but still they wanted some of the needs when it comes to the funds that you have said. They wanted some funds to be implemented to them also. And then as a conclusion.
Ma'am, your time is up.
Thank you. You are a very enthusiastic
Yes.
presenter. We like it.
Thank you, ma'am. So with,
Can
can I?
lack of time here. Thank you. Sorry.
Thank you. So lastly, can I conclude with a quote, ma'am? So in disaster darkness, unity shines brightest. So when it comes to disaster, people joins together and they keep up their hands together and they form the brightest together. So even in a disaster, it's the darkest, and people form and people started together and unite together to give a shinefulness of recovery statement. So with that, I'll conclude my session.
It was a social.
Yes.
Thank you.
Thank you.
Thank you so much. Now I call Ms. Ms. Priyadarshini and Ms. Vilpa Kumari to present their paper on the title Enactment of National Disaster Management Act, Creation of Authority at National, State and District level.
So, good morning everyone. My name is Priyadarshini and today my topic I will be presenting on enactment of National Disaster Management Act and creations of authority. So the overview of this presentation is introduction, background and creation of NDMA and creation of SDMA and creation of DDMA and their challenges and reasons, case studies and conclusion. So the intro, I have given the intro. Please change the slides. Next slide. So the intro is, we will be look at the creation of National Disaster Management Act, and we will cover up the setup of organizations at the national, state and the district levels, which each of these organizations does. Our goal is to understand the history that lead to the NDMA being formed, explain what these organizations are responsible for and talk about the challenges they faces and suggest ways to improve their effectiveness. So the background of the NDMA Act is, before 2005, disaster management in India was mostly unplanned and reactive. This means the response
response to disaster happened after they occurred without more preparation before it. There was lot of damages, and for example, the lack of planning became obvious during the major disasters like Odisha super cyclone in 1999, the Gujarat cyclone earthquake in 2001, and the Indian Ocean tsunami in 2004. So these events show that India needed a better, more organized way to handle disasters. And the purpose of the act is the legal and next slide please. The legal and institutional framework of disaster management. For example, they have brought like Disaster Management Act 2005, National Disaster Management Authority, state and district authorities, and National Disaster Response Forces. These came to the legal backbone for the disaster management in the India, forcing on reducing risk and responding effectively to the disasters. And the mechanisms for the prevention and mitigation and the preparedness is to reduce risk assessment and building goals and yearly warning systems. For example, in Japan, they are using yearly warning systems. So, like the technology developed countries using these type of yearly warning systems, it can be also implemented to India. And the preparedness is regular training and community involvement and resource planning to reduce the levels of disasters, damages. Next, creations of National Disaster Management Authority is established by NDMA and chaired by the Prime Minister. Is responsible for creating policies and plans for guidelines to manage disaster across the country, ensures an unified and effective response. And its function and key roles is to monitor and implement policies for disaster risk reduction across the country.
Ma'am, you have one.
Something related to finance, the fiscal, how they generate their fund, or how do they?
Fundings. Okay, allocations and utilizations of the resource remain inconsistent. The allocation and the use of resources for the disaster management are often inconsistent. This means sometimes there are not enough money, as you said, and the resources available when needed, which can affect how well communities can be prepared for the response to the disaster if the fundings, if the money which needed are getting. That's it. Then coordination issues. There will be gaps showdown in the sharings of importance formation and the resources, leading to delays in the responding to the emergencies. Let's come to the conclusion.
Ma'am, you have 1 more minute to wrap your presentation.
Okay. So the conclusion is, one second. The NDMA Act has created a strong base for the managing disasters in India. It set up a clear way to handle emergencies. For disaster management to work well, national, state and district authorities need to work together closely. The teamwork ensures that everyone can respond quickly and effectively when disasters happen. In the future, it is important to keep improving disaster management employees to adapt to new challenges. Community involvement in key. Local people can provide support and insight for the better preparedness. As they said in COVID-19 period, the people and the authorities are working together. Then additionally, using new technologies can help us predict and manage disasters more effectively. And the final conclusion is a good disaster management system needs ongoing improvement and active participation from communities and the use of technology to reduce risk and better prepare to future emergencies. Thank you.
Thank you.
Thank you so much. Now I thank all the presenters and for the resource persons for taking their time and joining us today. But before we end the session, I request Dr. Professor Vijay Lakshmi ma'am to felicitate our resource person, Dr. Anuradha Binnuri ma'am.
Assalamu alaikum wa rahmatullahi wa barakatuhu. Very good morning to one and all present here. Myself, Samsul Samira, Assistant Professor, Crescent School of Law. Feeling honored to host this engaging panel discussion on this two-day international conference on fiscal federalism with special reference to Indian Constitution. I'm excited to introduce our esteemed panelists who are experts in various fields. So first and foremost, we have Dr. J. Jayaranjan, Vice Chairman, Tamil Nadu State Planning Commission with us. He's an economist and he hails from Ilupakkore village in Tanjore district of Tamil Nadu. He was awarded PhD by the Madras University in 1995. He was a research scholar at the Indian Council of Social Science Research at the Madras Institute of Development Studies. He has taught UG and PG students for 5 years in Puducherry and he has completed 65 research projects, published more than 50 research articles in reputed journals and edited Dr. Jayaranjan's book in various universities like USA, UK, Germany and Japan. He has also published more than 100 articles and 7 books in Tamil on contemporary socio-economic issues and has participated in several debates as commentator on Tamil TV channels and social media channels. We welcome you, sir. Secondly, we have Professor R. Srinivasan, full-time member of Tamil Nadu State Planning Commission. Professor R. Srinivasan is a full-time member of SPC. He was a professor in the Department of Econometrics, University of Madras. Earlier, he was an economics teacher in various colleges across Tamil Nadu and Puducherry since 1988. He was also nominated as economist in the Tamil Nadu Revenue Augmentation Commission, Government of Tamil Nadu during the year 2002 to 2003. He has served as a full-time member and member in the State Planning Commission, Government of Tamil Nadu. He was the Registrar of the University of Madras during 2017 to 2020. We welcome you, sir. Next, we have our own professor, Professor Dr. M. Gandhi, Professor and Executive Director of Jindal Global Law School. He was the former Dean of VIT School of Law. He is currently serving as a Professor and Executive Director of Jindal Global Law School. He is an expert in international law with in-depth knowledge in constitutional law and jurisprudence. He has specialized in various areas including UN and international law, multilateral negotiations, and legal advice on issues like the law of the seas, international humanitarian law, international trade law, international criminal law, and refugee law. We welcome you, sir. Next, we have Mr. K. Jodi Shivanyanam. He's also a professor. He's a member of Tamil Nadu Public Service Commission. Very recently, he has been relieved. So he has been engaging in teaching and research leading to policy formulation, its dissemination through extensive writing and speaking. He has taken various positions for the administration of higher education for the past 3 decades, from 1987 onwards. He is currently the professor and head of the Department of Economics. He has co-holded various positions and he was appointed as the member syndicate convener committee of the University of Madras. We are very happy to have you, sir. We welcome you. Last but not the least, we have our Dr. C. Manikum sir, ex-IRS, founder and director, Tax Law and IPR Consultants. Sir has completed his LLM and he also holds a PhD degree in law. He has secured first rank with specialization of jurisprudence, constitutional law and commercial law at the School of Legal Studies, Cochin University of Science and Technology. In the year 1997, he cleared the Civil Services examination and joined in Indian Customs Revenue Department, Ministry of Finance, Government of India. Since then, worked at different sections of the Customs and Central Excise Departments. He also handled litigations at various levels such as Commissioner, Settlement Commission, Tribunals, High Court and even Supreme Court. So after an excellent and meritorious service to the government, he resigned from the IRS and he founded Tax Law and IPR Consultants. We are very happy to have you, sir. Please welcome. So with regard to our international conference, we will be having 3 sessions simultaneously in the auditorium and in the seminar hall. The first session was based on the theme that impact of GST on federalism and fiscal autonomy. We had more than 20 participants presenting the paper And the second session, which took place post-lunch yesterday, was based on the theme of disaster management and federalism. And the third session took place on today's morning session, handled the theme of constitutional framework and autonomy. We are very happy to say that we had excellent research papers from all over India. We had excellent engaged listeners for all the three sessions. Now I invite all the participants and the listeners to have an open discussion with the panel. We are looking forward for an active participation and active collaboration. We would like to know from the part of the government how actually this fiscal federalism is going on what can be done for making more important initiatives. Open to the panel.
Good morning, everyone. I'm very happy to be part of this panel that you have organized. This is a very important topic on which the seminar has been conducted for the past 2 days, the fiscal federalism, with a special reference to Indian Constitution. The present day context, the topic becomes very, very important. Now, the panel discussion can be structured in the following way. That's what I feel. Each one of us, each one of the panelists will have about 5 to 7 minutes to present their viewpoints. Then towards the end, I'll sum up the discussion, and then we will open the floor for question and answers. Now may I invite Professor M. Gandhi to share his views on the topic that has been assigned to us. Over, Professor Gandhi.
Thank you very much. I am privileged to be on the panel where, well-known economists are here, along with another lawyer on my left side. He's a taxation specialist, and you know that, after all, the fiscal federalism, it revolves around taxation policy and revolves around how the taxation is taking care of the government for the whole, that is the center, and government for the parts, that is the states and the UTs. It is, the fiscal federalism itself is coined the word by Richard Musgrave in 1959. He's an economist. And the idea of fiscal federalism that you can find not only in the federal constitutions, you will find in all constitutions. If you look at the history of evolution of fiscal federalism, you can just go back, not now, even the 35 Act or afterwards. You can go even before that. It's all started even in 1800 always. So even that was only the unitary government at the particular point of time. They talked about fiscal federalism. That means how the parts of that governance, they will get benefit out of the tax revenue and other revenues for the purpose of, really to undertake the works that are assigned to the parts of the government. So the fiscal federalism need not be only in the federal setup, it can be anywhere else. This is the first point. And second point, as far as the international, the Indian constitution is concerned, the federalism, and you can say that a section deals with finance. It's a very lengthy section. But where if you see that provisions, the provisions are carefully drafted, it is well balanced. When it started the codes of life as the federation, thereafter what happened was that the working of those principles of a fiscal principles, and that all in fact controlled by those who are all in power. That you can see. But this is not new for India, and this is the tendency all over the federations, wherever it is. Whether you take it to USA, you take it Canada, you take it Australia, because the provisions we borrow it from the the Canada and Australia in our constitution, where you can find that all the the democracies, when they put in power continuously, and the structure always will have centralizing tendency. And the centralizing tendency, you can always find, it is felt when you read the working of the federal structure in India. Now, there are two issues here. How we are getting the states, the parts, getting the actual, the money that goes there. The taxation policy is there, the taxation provisions are there, how it is collected, how it is, they got given to the states. But in addition to that, there are provisions for, grant in aid. There is a provision for finance commission. Now there is a provision for local youth. In all these things, if it is all the, the fiscal power sharing structure, if that is controlled by center, naturally, whatever, the center says, the same thing will happen. So what is happening is that the center being a powerful apparatus, and especially, if you see that the GST, now, if you say that the GST Council, you can see that it is 3/4 it is essential for the purpose of, deciding any matter. But 1/4 holder is what? It is only the union government. But 1/4 will control the entire thing, but almost they have a veto. So whatever is given to the states, which are all completely controlled by them, not only that, grants and aid, because there is a provision that, it should be balanced and it should be equity based. If it is a equity based where there is no allowances given for the states which are all progressive, because, they are in fact developing so much, and the developed states are within the federation, they are looked down. They are not, treated well. So it is not that only the equity needs to be looked into, and you have to see that what is the promotional activities as far as the welfare of the people are concerned, that also must be taken into consideration if it works really as a federation. And I think, the time limit given is over, and I can just give it to my next panel member. Thank you.
Since the first perspective has come from Professor of Law, I think the next perspective will come from economist. So I hand over the discussion to Professor Jyoti Sivanyana.
Respected chair and the panelists and professors and students, I'm happy to be here. As professor initiated, we are also teachers. So let me begin with the definitions. Let me introduce the concept. Federalism, what is federalism and fiscal federalism, and how it is structured in our constitution, and then what we are facing today, how it is being practiced. I try to be brief. So for federalism, what is federalism? I would like to quote a recent Supreme Court judgment on the case concerned with the rights of the states to levy cess on mines and minerals. It is a case, they have delivered a judgment whether states have the right to levy a cess on the royalties charged by the union government on mines and minerals. Okay. So the judgment is running like this. Indian federalism is defined as asymmetric because it tilts towards the center, producing a strong central government. Yet, it has not necessarily resulted in a weak state governments. The Indian states are sovereign within the legislative competence assigned to them. In a federal form of government, each federal unit should be able to perform its core constitutional function with a certain degree of independence. The Constitution has to be interpreted in a manner which does not dilute the federal character of our constitutional scheme. The effort of the Constitutional Court should be to ensure that the legislatures are not subordinated to the Union in the areas exclusively reserved for them. So this is இல்லை அது ஆஃப் பண்ணிடலாமே கண்ணா. So this is almost a textbook definition given in 1946. The court judgment emphasized that the state government has got independent authority. It has got sovereign powers, and it has got independent authority to legislate in the domains given to it. So that is the definition the Supreme Court conveys to the union government, which is fighting against this. So it doesn't accept this. Union government doesn't want to accept this independence of the state authority or sovereignty of the state authority. They argue that they don't have the right to levy a cess on mines and minerals. So the Supreme Court has to educate them. And this is almost a simple definition given by one of the earliest authors, K.C. Weir. Actually, Srinivasan gave me the book in 80s. The federal government, that book has been a teaching material for DMK parties in 67, 70s. The பயிற்சி பாசறைன்னு பேச்சாளர்களுக்கு நடத்துவோம். They used to quote this definition. See, let me say what K.C. Weir has said. K.C. Weir defined federalism as the method of dividing powers so that general and regional, that means union and state government, are each within their sphere coordinate and independent. So there are two different tiers of government, union and state government, and they are been given different powers, and they can coordinate wherever they have to interact with each other. They can coordinate in other areas which are exclusively given to them, assigned to them. They can be independent. So union and state doesn't mean that one is authority, another one is a subordinate. They are parallel governments, independent, having independent authority, sovereign powers in their own respective domains. This was the original definition of federalism given by K.C. Weir. Supreme Court underline this definition. So state governments are independent. They are not subordinate to the union government. This is the definition of federalism for so many years. Now, what is fiscal federalism? Now, fiscal federalism is simply, we used to say, it is an assignment of expenditure and a taxing responsibility. Expenditure responsibilities and a taxing powers. So these two different tiers has to be given different expenditure responsibilities. And they have to collect revenue. So revenue also be assigned to them, and they have to do, and certain areas both will work together. So for this, another textbook sir has quoted Musgrave. The first chapter explains about that, how allocation, distribution, stabilization functions are assigned to different levels of government. Normally, the union government, it is the responsibility of the union government to address the macroeconomic concerns, the issues that has to be addressed at the national level. For instance, stability, distribution, allocation is given to the lower level government, and even the union government has got the responsibilities. So given this context, fiscal federalism, I wanted to quote another report, newspaper report that appeared yesterday. It just struck me. The minister, Dharmendra Pradhan, he has given a report yesterday, Times of India, it is available, you can read. He accused the opposition ruled states are responsible for unemployment in the respective states. Whereas the BJP ruled states are having very good employment opportunities. There is no unemployment in those states ruled by BJP. So it is only the opposition ruled states are responsible for unemployment. This is exactly as said. So unemployment, if we talks about the macroeconomic objective, or even stability, is a question of economies goes in cycle. So it is exactly the responsibility of the union government. In 2014, The BJP promised to create 25 crores of jobs for the next 10 years. They assume that they will be get elected for the next term also. So they promised to deliver 25 crores of jobs. That means 2.5 crore job every year. If it is the responsibility of the state, why should they promise for the union election, general election, parliamentary election? So they promised and they could not deliver. That is a different story. But this is about fiscal federalism or assignments of different functions. So how it is exactly done in our constitution? There are 3 articles from our constitution I want to underline. The first article says, India, that is Bharat, shall be the union of states. Sir, timer. Okay, so union of states. Then the entire 7th schedule lists out the taxing and expenditure responsibilities for the union list, union government, state government, and the concurrent list where both has to perform. So now during these 10 years, last 10 years, the transfers, see, there are imbalances between the assignment, the Constitution created Finance Commission to address the vertical imbalance. The union government has got more revenue, less expenditure responsibility, 2/3 of the revenue they collect, but they have only 1/3 of the expenditure responsibility. Whereas it is a reverse in the case of state government. State government has got 2/3 of the expenditure responsibilities and 1/3 of the revenue. In terms of development expenditure, state government has got 80% responsibility. The union government has got only 20%. To address this imbalance, the finance commissions are created. Now, last 10 years, whatever we have been doing earlier, and compare with that, the transfers as a whole from the union government to the state government has declined from 6.1% of GDP to 5.5%. That means for 23-24, 1 year, the state governments are losing 1,77,000 crores because of this cut in the transfer, all transfers put together. So similarly, if you look at the same problem from the state government point of view, if you take the expenditures as a ratio of the state government total expenditure, all the state government expenditure, the decline is even more sharper. Earlier, in 2013-14, the state government's transfers as a ratio of state government expenditure was 38.1%. Now, in 2023-24, that has come down to 31%. So, almost 7% transfers to all state governments are cut. Now, that is vertical transfer. That means some 3.88 lakh crore rupees every year. Now, horizontal transfer. Earlier, we used to debate about southern state, northern state, developed state, underdeveloped state. So, like that, we used to comment about the Finance Commission transfers because they, as the earlier speaker said, they give more weightage to equity consideration rather than efficiency. Now, what is happening? It is opposition-ruled states and BJP-ruled states. The developed and versus developing states has changed into. So, these openly governments declare this double engine growth. What it means is, if you are giving a chance for BJP to rule your states, you will get more financial support. No formula, nothing. We know how to do that. So, if you are ruled by opposition like Tamil Nadu, you have to suffer. And now that also got modernized, further advanced. This trend has advanced recently after the current general election. It is not only the BJP ruled states, within that only 2 states, AP and Bihar. Because this government depends on their support. So only these 2 states will get whatever they want. The rest has to suffer. Thank you.
Both the previous 2 panelists have highlighted the way in which the union and state relations are going on, and particularly in the present day context, where the states, particularly those who are performing very well in terms of development and also in terms of the population control, are all being victimized in terms of devolution of money from the union to the states. And now Jyoti has taken it to another level. It's not just the general states alone. Now, the earlier pretension was that in the name of equity, those states which are remaining underdeveloped were given more finances, more resources to develop fast and catch up with the developed ones. Now they have given up all these pretensions. Now they are very blatant about it. Now they say that either you are with me or you are not going to be with us. So that is what is happening. Not Bush, but generally the right-wing people, whoever it is, either it is Bush or Trump or whoever it is, they practice the same language. And yesterday our Chief Minister had returned from Delhi. You see, if you see the memorandum what he had submitted to the Prime Minister, it's very clear that they have put up 3 requests. One, the equity participation in the metro project. They initially approved the phase 2 of the project, and the commitment was something like 62,000 crores. And if the state government puts in 7,000 crores, the union government has to put in another 7,000 crores. Rest of the money will be borrowed and it will be repaid. That is the arrangement. Now they have quietly withdrawn that, which means all the 62,000 crores have to be borrowed by the state government. And it's not only just the borrowing. Anyway, we are going to repay. Even if they participate in equity, the state government is obligated to repay the loan. But the problem is, this amount will get reflected in our debts, in the state government's account, which means our borrowing capacity will be heavily reduced because of that. That's why now we are requesting them, we are appealing to them that now they should take it up as a central project. So it is very blatant. Except for Chennai, they have funded all the other metro projects in the country. So that's what is being highlighted by 2 of our earlier panelists. I will not elaborate more on this now. Now may I request the third panelist, Dr. C. Manikam, an ex-IRS officer, to present his views on the topic.
Good afternoon, everyone. It's a great privilege to sit with experts, especially I admire only a very few people. One among them is Mr. Jayaranjan, because his ideology, commitment, and dedication towards the subject, or his vision, I used to admire. With this, I may take little time, sir, because since I am a constitutional law student and the topic is very close to me, since yesterday I have restrained to come here because if I come the entire session I will be speaking. I will be troubling the participant. That is the reason yesterday I did not come. So with this background, let me get into the topic. My first would be, I have seen all the videos of the yesterday presentators and resource person. The idea of this seminar or the conference is to create a mind for you to think independently, to critically understand about the Indian Constitution, and for the future generations, how the Constitution as a political functional document has to be understood, has to be elaborated, has to be interpreted to hold the country as a nation. Please aware, dangers are imminent. Everyday complex problems are arising in the governance. Either you take the union government or you take the state government, there are multi-number of problems are emanating from one side to another side. So therefore, the Constitution has to provide answer to all the problems in the context of the jurisprudence. Therefore, I have divided my speech, or rather discussion point, in 4 folds. First, I will request the students and the research community, you have to go a little more deeper into your research approach. For example, when Professor Sivayanam and Professor Gandhi was referring about few definition of K.C. Ware and the other authors as well as the 1935 Act, you all have to appreciate, relatively our constitution is a young constitution. young constitution and the lengthiest constitution. So when in 1950 we got an opportunity to make this constitution, we had great literature available in different countries. For example, if you take part 4 of the constitution, we are taken from Ireland. Part 3 we are taken from England and USA. Like this, amending power we are taken from Australia. So Canadian, Australian, Switzerland, many constitutional provisions are examined and a combined approach was adopted to make this constitution. So therefore your research endeavors, because yesterday even I could see Dr. Ambrose was raising certain questions about 1935 Act, historical evolution, what is the relevance in the context of GST, your researchers should have clarity. So for that, you have enough materials. So therefore my request would be, you have to structure your ideas, because you see it's not mere seminar. It is creating ideas. These ideas have to go for further discussion, and the discussion point should create a conceptual philosophical content which should be the base for framing the public policy. So therefore, we have enough materials. You take the Constitutional Assembly debates, enough discussion was there. Then 1967, there is the Administrative Reforms Committee. Taxation powers were discussed. And Tamil Nadu being the torchbearer of federalism and independence of the state, 1971, Rajmanar Committee was appointed. They submitted the report. 1988, Sarkaria Commission submitted the report. 2010, Federalism and Administrative Relations, one more committee has submitted the report. Then there is a Punch Committee, Vijay Kalkar Committee, and then subsequently now the 101 amendment of the Constitution, which has resulted in bringing the GST law. So when you talk about fiscal federalism, we have to understand what is the provisions of the Constitution and how these provisions of the Constitutions are interpreted today, are applied today, and next 50 years or 100 years when the country has to survive, whether these provisions are going to answer to the problems or not. That is the reason I told we are apprehending a danger. Unless the Constitution is interpreted or applied in a equitable, fair and reasonable manner, obviously there will be an element of violation of rule of law. We should not allow it to happen. Therefore, our ideology should be based upon evolving the concept of real federalism, because all you are aware, India is not a pure federal country. So therefore, the comparative perspective is very important. When we talk about comparative perspective, America, the powers are concurrent in nature, especially taxation powers are concurrent in nature. Both Congress and the states are entitled to levy taxes. Canada, it is a demarcated approach. Whereas in India, we have adopted a unique approach wherein the Constitution has tilted, especially when you look at the entry 97. Entry 97 of the Constitution has given the residual powers. So our Constitution has given residual powers to the Union government. So therefore, it is called as an imbalanced Constitution, tilting in favor of the revenue. So we had lot of crises in the past. From 1950 to 2075 years, we have witnessed many problems. In terms of political turbulences, in terms of fiscal turbulences, we have witnessed. Political turbulences, especially with respect to 356, in the case of SR Pomai versus Union of India, the Supreme Court of India has held that federalism is the basic structure of the Constitution. But now we witness the fiscal federalism, especially with the introduction of GST law. Definitely the states have surrendered their rights to the Union. When they have surrendered their rights to the Union, how the fiscal autonomy can be protected? What are the leeways? Or whether thinking process can be altered? When we talk about GST law, whether the GST law has envisaged autonomy of the states, whether the compensatory mechanism which is prescribed for 5 years now extended to up to 26, can it go forever? What kind of legislative changes are required? So these are the ways in which I request the researchers to understand about the Constitution, to make the Constitution more relevant. So with this introduction, now let me get into a few areas about GST and federalism, because I have seen many of the speakers were talking about GST. What GST has done to the Constitution? Please appreciate the fact, the power of state to levy tax predominantly in the form of sales tax. The Union had the power to levy tax on manufacturing and service. So an element of cascading effect has not been understood, and the trade and industry were of the opinion that they could not take input tax credit in a seamless manner. Therefore, tax compliance was considered as a burden for the industry. In order to address or redress the grievance of the trade and industry, they wanted or make a new GST law. With that, there were many number of discussions, because when Congress government, UPA government introduced GST model paper, that was a different concept. They were talking about duality. But when 101 amendment came, it has become a document of empowering the union and surrendering the constitutional rights of the states. Therefore, a major question comes. So what was the promise? In order to redress the grievance of the state or the expectations of the state, they introduced the GST compensation. So my approach would be, or my suggestion would be, how the GST compensatory mechanism has been done. Whether it has been done correctly, whether it has to be continued, if there is a flaw, how it has to be set right. So let me put it few ideas how the GST compensation cess has come. In the constitutional amendment, there was enough discussion about compensatory principle. How this mechanism has come, how it is going to work. Because today paper also you have seen, they have appointed a committee to look at it. Today morning newspaper it is available to extend the benefit of compensation for furthermore state, even after 2026. While doing so, whether they have done the correct thing or not, because please appreciate it, GST compensation cess, they promised that there are many number of cesses are available pre-2017, 1/7/2017. These cesses would be subsumed in the form of GST compensation cess. And major cess was collected, clean energy cess. So clean energy cess was collected for the protection of environment, but that was abolished. Now it is renamed, because now when you look at the GST compensation cess, around 40% of the cess comes from the coal imports or the coal rearing from the mines. So now they made the compensation cess. So the point what I would like to emphasize, what they have done in the name of compensation, they have snatched one area and created a gap with respect to environment protection, and they want to mitigate the losses to the state in the name of GST compensation. Therefore, my suggestion or idea is, the union has to think about what should be the real compensation. Then the question comes, how to identify the real compensation. As Mr. Jyoti Sivanyana was mentioning, the judgment has come. Mineral Area Development Authority versus Steel Authority of India Limited in 2024. What was the judgment? The union was arguing, in the name of Mines Regulation and Development Act 1957, they have not only the power to regulate and administer the mining activities, but also to determine the levy of royalty on the resources which are taken. So there was a dispute, because India Cements went to Supreme Court. 15 years back, the judgment was given. There was a contradiction. Now 8:1, the Supreme Court has held that the state has the power. So what is the point I would like to emphasize? The point is, now when we talk about Finance Commission to divide on equitable basis, this judgment has given a catalyst for the state governments to alter the criteria adopted by the Finance Commission with respect to devolution of taxes. So Finance Commission adopts certain methodology to devolve the taxes. By virtue of this judgment, states like Jharkhand, Bihar, Madhya Pradesh, West Bengal and Orissa will have more avenues to get more taxes, because by the judgment, the states were empowered to collect taxes. Even the Supreme Court has clarified this levy can be done retrospectively also. Meaning thereby, past 10 years or 15 years, what was the pending taxation can be collected by the states, by in which the states are going to get additional resources. There will be a cushion for the states. So in the context of this judgment, what Tamil Nadu can do it in the context of federalism. Because as you are aware, in TV channels and media reports and newspapers, we read much about sand mafia or mine mafia. So this judgment is an eye-opener for the administrators, and we have to go for fiscal management and collection of taxes for the mining activities in a prudent manner with transparency. How to do it? This is one of the major exercises which has been carried out by all the state governments, because now you are aware there is a blockchain technology. Geo mapping can be done. Geo mining can be done. Artificial intelligence can be inducted. You can understand what are the resources. How much is there, how much is left out? All these things can be regulated by the blockchain technology and artificial intelligence. So for the tax efficiency, to increase the tax of the state, this judgment has to be used as a potential input to increase the collection of taxes. And second aspect, I have many more aspects because my time is very limited. I have been given a warning signal. I'll take 3-4 minutes. Second aspect, I would like to suggest, because in the context of disaster management and the compensatory jurisprudence as evolved by the Supreme Court of India in many cases, R. Gandhi, Olga Tellis, Vaman Rao, and many more judgments, it is the responsibility of the union or the state government to provide health, sanitation, housing, water, everything to the citizens. It is a part of Article 14 and 21 of the Constitution of India. So, to prevent the natural disasters and to mitigate the losses arising out of the, what can be done? How the state can maximize the revenue collection. So, I would like to propose a floor for discussion, especially the panelists to have a discussion on this topic. I propose to make a law in the name of public health. Please make a legislation by state government because health is a state subject. So what way the modality of taxation can take place? I'll give 2-3 examples. Tamil Nadu may have 1 lakh mobile phones, or 1 crore mobile phones. All populated printed circuit boards, wherever it is integrated as a component, and for protecting public health, with respect to all the populated printed circuit boards used finished products, such as mobile phones, air conditioners, laptops, scanners, X-ray machines. Because these ideas you have to take from the Western countries. When you look at the European Union, even yesterday newspaper, some of the panelists would have read or you would have read it. European Union now says, in case you want to export the agriculture product, you have to give a declaration that these agriculture products were not originated or produced from the deforested area. Meaning thereby, in case the land, forest area is cleared and you have done the cultivation, commercial cultivation, don't export such goods to our European Union because they are bothered about environment. Similarly, they have introduced one more levy, border measures. If you have not protected your environment in the process of manufacturing, don't export the goods to European Union. If you export, you pay tax. So they are so bothered about environment botheration, and your disaster management as a serious problem. It is going to take much of the administrative skills and the resources to tackle the problem in a serious manner or to address in a serious manner. Some revenue should be there with the state, and this type of fund can be used by the state in the form of state disaster management fund, and the panchayats and municipalities have to be empowered to deal with all these issues. Then only the state can have real autonomy. So I have some more ideas. Probably our panel chairman will give some time. I will read your questions. You please read your questions later. With this, thank you.
The problem is that, he is a professor. Both these two are also professors. He is a lawyer. All of them are used to know when they get a chance, they will talk for a minimum of 1 hour. So the panel should have been at least structured for, let us say, 6 hours. Then only it will do justice to the topic as well as the panel that we have here. Now, I have another problem. My fellow member in the State Planning Commission, I used to call him as a man of few words. So I hope that he will confine his presentation, or in the, as he has argued a case, if you want to argue a case, let the argument be within 5 to 7 minutes. Over to Professor Srinivasan.
I've always been a man of few words, even in my class. So, I strongly believe that Indian Constitution is very flexible. It has been amended more than 100 times. It has been variously interpreted by courts, and practices also differ over time. One classic example is the terms of reference to the Finance Commission. Article 280 gives the terms of reference. That terms of reference appeared only twice in the history of Finance Commission, in the first and the second.
Thereafter, the terms of reference kept on extending because there is one provision in the terms of reference, any other matter in the interest of sound finance. That small part of the terms of reference gives enormous powers to the union government to extend anything under that particular class. So if you read the terms of reference since the third Finance Commission up to the 15th Finance Commission, you will find the terms of reference extend to several pages. One of the longest terms of reference we have had was the 15th one. And you know that who conceived that terms of reference for the 15th Finance Commission. Contradicting that, the 16th Finance Commission has one of the shortest terms of reference. It just reproduces what was there in the first and the second Constitution, Finance Commission. So why there is a sudden change of mind for the same government to give a very long terms of reference for the 15th and a very short terms of reference for the 16th? I think it is basically they knew that who would be the chairperson of the Finance Commission. Because the present chairperson is known to have openly declared his position along with the political bosses of the system. We expect a Finance Commission to be a neutral body to adjudicate between the union and the state governments on the claims of common resources. Whereas we have a chairperson who is known to be very close to the establishment at the Delhi. Maybe that gives them the confidence that whatever be the terms of reference, the outcomes would be as we expect that. If you derive the lessons that we have learned in the third Finance Commission, there was an argument whether the Finance Commission should recommend grants towards plan expenditure. Those days we had Planning Commission also. The Finance Commission recommended grants for the plan expenditure as well. An IAS officer who was a member secretary of the Finance Commission gave a dissenting note that the Finance Commission should not recommend grants for the plan expenditure. The Parliament upheld the dissenting note, not the full Commission's recommendation, and cut the planned grants. Once again, in the fourth Finance Commission, this discussion came up. If you read the recommendations, the report of the fourth Finance Commission, you would come across. Then the K.K. Venugopal was asked to give his opinion on this. And the report says that K.K. Venugopal then gave an opinion under Article 275, the Finance Commission can recommend grants for plan expenditure. But even then, the Finance Commission did not approve that. Thereafter, the planned grants were moved out of 275 to 282. So, thereafter, the planned grants were under Section 282, not under Section 275. So, this is one case where we find the practice changes over time, the Constitution remaining the same. You take the case of share of states. Since the first Finance Commission, West Bengal and Maharashtra consistently argued that contribution to the tax should be the base for distribution of tax revenue to the states. But it was not approved by the Finance Commission for various reasons. That is too technical in economic jargon. I will not get into that. But that debate went on for about 2 to 3 Finance Commissions thereafter. And then it was decided we will not allocate money based on contribution. So they went into some proxies in terms of demand and efficiency. Once again, now there is a need to look into the contribution. You would have listened to Jairanjan many a times. He insisted how much of money that per capita tax revenue raised in Tamil Nadu under GST and the per capita tax revenue raised in Uttar Pradesh under GST, which shows that our per capita revenue realization is far ahead of what Uttar Pradesh contributes to the central treasury. So having contributed more, we have been receiving far less. So this is once again creates the debate of whether contribution should be the basis of transfer from the union to the state. So once again, the terms of reference remaining the same, the interpretation could change over time. So what I want to emphasize to you is read the constitution, but also read with a critical eye that underlying practices will keep on changing because the underlying society is not stagnant. Your constitution can remain stagnant in letters, but in terms of practices, it has to respect the underlying federal society and their aspirations. To give you one more example, I will stop with that. The National Family Health Survey of 21-22, it estimated there are about 11 million teenage deliveries in India. 11 million. But the number of cases registered under POCSO is only 68,000. That is, it is about 5% of the cases. So this is the practice we have, where we know blatantly that 11 million children below the age of 18 have been made pregnant, but only 0.5% of that cases have been registered. This is the practice of law that we have in this country. Thank you.
Before opening the floor for question and answer session, I thought I'll sum up the panel discussion so far and also put forth my take on the whole subject. Now, Professor Gandhi traced the history of the Constitution as well as how our federal structure has evolved over time, and he said that the inequality in terms of devolution as well as tax flows from the union to the states in the name of equity, and how it has to be taken into account while understanding the functioning of our constitution. And Jyoti again came to the same conclusion, but he said the devolution as well as the flows are not even hidden in the name of equity. Now it is very blatant politically, and if you are pro-establishment, pro-union government, then you will get a larger share in the devolution, and if you are in the opposition, it will obviously come down. And the third panelist, Dr. Manikam, he argued the case that how the GST, when it was introduced, how it robbed the powers of the states to levy taxes. And that is a very serious kind of a loss for the federal structure to safeguard the interest of the business community. That we have been arguing for a very long time, and that it should not have happened, but it has happened. Now, how do we compensate for that? So the Finance Commission has to take that into consideration in its deliberations. That is his position. And Professor Srinivasan, in his presentation, had argued that don't have such huge hopes about the Finance Commission, because the person who is put in charge of the Finance Commission now, as well as the terms of reference that has been given to him, are not very optimistic. In the sense, what we may not get the justice done for the states that are being penalized. That is his take. Now, the overall picture that I get here is that the union and the state relations is a very important topic that you have to understand, and particularly of students of law. It is very important that you go through the Constituent Assembly debates and understand the various positions and how Ambedkar argued that no, whatever is possible at that point of time, that he said that he has tried. Now, he also reposed confidence in us as the citizens of this country, that based on this experience of, let us say, 75 years or 77 years of the federal functioning, you can revisit the constitution and make necessary changes whichever you deem fit. That's what he said. And given the present structure of a very powerful center, whether it is given or assumed, we do not have much of a hope that that would happen. But that doesn't mean that we can just give it up like that. That's why we keep on raising this issue about the imbalances that it has been created and sustained by the union and how it is not right. That is our position. And particularly, Tamil Nadu is in the forefront in arguing for the rights of the states. And you should also go through, as Dr. Manikam had suggested, the documents that we have prepared and the kind of memorandum that we have submitted to various finance commissions about the rights of the states, and that would give you a very good understanding of how a robust federal system would function if all these demands are met. With those words, I would like to throw the floor open for the question and answer session, and I think each of our panelists will take a couple of questions to answer. It's open to the floor. கேள்வி கேட்கும்போது அந்த கேள்வி யாருக்குன்னு சொல்லி கேளுங்க. அந்த பேனலில் யார் இருக்காங்களோ உங்களுக்கு. அப்படி இல்லைன்னா உங்களுக்கு யாரும் ஸ்பெசிஃபிக்காக இல்லைன்னா கேள்வி கேளுங்க, இங்கே இருக்கவங்களே டிசைட் பண்ணிக்குவாங்க யார் அதை ஆன்சர் பண்ணுறாங்கன்ட்டு.
So what is your view upon delimitation, the representations on behalf of the states and its impact on federal structure of the country?
Though it is totally out of the context, in terms of delimitation, if you look into the practices of other federal countries, Canada has been practicing delimitation in a way that the smaller provinces are given larger amount of representation in their parliament, disproportionate to the population. Whereas the larger provinces like, what is it? No, that is a French province. What is it? Yeah, Quebec. If you compare Quebec with smaller provinces like British Columbia, you will find it that Quebec doesn't have as many MPs in the parliament as proportionately as that of British Columbia. So this they have been moderating over a very long period of time. Basically, the idea comes from the liberal attitude of making the minorities safer in a context of majority ruling. So a majority ruling is acknowledged as good as long as the minorities feel safe. It can be in terms of minorities, I mean, it can be linguistic, it can be regional, it can be religious, anything. So if this attitude is also brought into the system of delimitation that we will have in the next delimitation exercise that we will do after the next census, then the southern states' general fear that they would be losing more number of seats would be addressed. And there are more than one ways of doing it. We could also do that.
We are in India. So the political idea behind this is totally different. Here the purpose is exactly the opposite. What Srinivasan has said may be happening in Canada. In India, already the southern states are what we say the developed states who have controlled the population are suffering from the Finance Commission devolutions. Now this is yet another blow for them. Their MP constituency will be reduced based on populations. So the ruling government thinks that they can win most of the seats from the northern India, Hindi belt, whereas they are not winning as much seats from the southern India. Particularly Tamil Nadu is refusing to give even one single seat. So without they don't want to depend on us. So politically, because this issue has been all along, every time the parliament discuss this issue, they postpone this. Now they are giving serious attention. They wanted to do it now. So after conducting this census, they wanted to do it seriously, 24. So it is purely a political agenda to cut down the share of member of parliament from southern states and then proportionately increase those seats to the northern belt, UP and Bihar. That is the political agenda behind that. Thank you.
Next question. More respected, esteemed personalities on the dais, my colleague and students. Good afternoon to everyone. Sir, it's not about question, just need a suggestion regarding 2-3 points of intergovernmental fiscal relation point of view. When we talk about the current revenue sharing arrangements between the state and central, so on point of your view, sir, how it is effective and what reforms could need to improve and equity. So second point, sir, as sir already told regarding the present ruling government, so if it is a need of any state, obviously the BJP, they will help them more than other. So we are some states which we are failing challenge faced by the Indian states to achieve the fiscal sustainability. And how can they address it? Through policy reforms. For example, I will take on example on that Jammu and Kashmir state. As sir also told, there should be a strong relationship between central and state. But when we talk about that regarding the fiscal sustainability, we are very lagging over there. So anyway, I think this is the main reason regarding peace are all reasons, all the hesitations, if I point out, because of infrastructure and fiscal sustainability. So how we will address those points through policy reforms. And my third point is regarding borrowings, which we have limited, imposed on the states, ability, finance, infrastructure and development. Sir, do you think like these impositions should be reconsidered? Thank you, sir.
It is an interesting thing about the borrowings. I concentrate on that. The government of India can indulge in unlimited borrowing because the Reserve Bank is there. You ask for that, they are going to give it. But whereas the state borrowing is concerned, it is one way or other, it is controlled. And the panel speakers, one of them were telling that already when you are committed and you are borrowing things because the center is not supporting, then there is your possibility is that you will be more burdened with your debt. Therefore, additional borrowing will be limited. So the borrowing plays very important role in the fiscal system, and that the control is with the central government, it's the union government. Therefore, something needs to be done on that. That is my feeling.
See, as well as the state reorganization is concerned, what we are afraid is it can happen to any other states. See, 370 is one issue, but splitting them into union territories, couple of union territories is a serious challenge. Abrogating 370 is different. But splitting them into union territories, centrally administrated territories, is sending a message to other states. That is one thing. About the borrowing, in public finance, we have got a parallel branch called public choice. So in public choice, the public finance believes that government is benevolent, so they are supposed to do such and such a thing, fiscal policy, macro policy, these functions allocation, everything they have to do, because we believe that the government is benevolent, they are supposed to do good things. In public choice, we assume that government is run by individuals like you and me who are driven by self-interest. And three major representatives of this, our current representative democratic system is the politicians, and then individual voters like you and me, and then bureaucracy. So all these three sections are driven by self-interest. What is the self-interest of the politicians? To be in the chair as long as possible. So they will promise to do so many things to remain in the chair. That is their self-interest. Similarly, the voter taxpayer, we wanted to pay less tax, get more benefit out of the government, and that is our objective. So accordingly, we will behave. Similarly, bureaucracy try to have the larger budget for their department that gives them power. So when these are the different self-interest, conflicting self-interest, how they reconcile with each other, how system works, that is the area, public choice. So they have given recommendations to put restraints. Their assumption is the individuals will behave, politicians will behave fiscally irresponsibly. So they may borrow more, but collect less tax. That is what exactly is happening now. We have cut down the direct taxes. The government has increased its borrowings. It's borrowing, so the public choice wanted to impose a limit, a restraint on the fiscal irresponsible behavior of the politicians. So we have enacted an act, FRBM Act 2003-4. So the act says it is a prerogative of the parliament to make any expenditure, to collect any revenue. But we will impose a restraint on how much that you can borrow. So you can borrow for your capital expenditure to the maximum extent of 3% of GDP. And for revenue expenditure, you should not borrow. So revenue deficit should be 0. Fiscal deficit, that is for capital expenditure, can be 3% for both union and state government. Now the union government is having from 5.5% of GDP, more than that. Similarly, state government borrowings have increased during the last 10 years. Last 10 years, they are all together, all state put together, have borrowed around 21.9% in 2013-14. Now they are borrowing, all states put together, 28%. The FRBM ceiling for debt, public debt, debt to GDP ratio I am telling. So the FRBM target for deficit is fiscal deficit 3%, revenue deficit 0% for both. And debt, the union government can borrow or can have 40% of the debt as a ratio of GDP. State government can have only 24%. During COVID, we have extended that 5% some relaxation. So now the state governments have borrowed more, 28, and the union government debt is some 60%, I guess, 57 point or 58%. So that much they borrow, they breached all the targets because they cut down the tax revenue. So this is exactly the reason why we enacted FRBM. But as Srinivasan said, we always have a way out to go against the...
So I will answer two of your aspects. One is on relationship between the union and the state. That is a political question. As I told you, S.R. Bommai has given a great importance to the federal aspect. And the union cannot invoke 356 in a unilateral manner to destabilize the elected governments. But when you look at the context from the division of states, especially from JK, and now as others are mentioning, it may happen to any states, even Tamil Nadu also, they talk about Tamil Nadu may become 3 states like that, Konkan belt or some central belt, northern belt. Yes, the judgment delivered in the year, this year, by the Supreme Court is not a correct judgment. Many of the jurists have already criticized, because any division of the states, the recommendation should come from the state legislative assembly. So when the constitution was interpreted, the question was whether there was a state legislative assembly in JK, whether the governor can be considered as the state legislative assembly. Unfortunately, Supreme Court has assumed state assembly means even after dissolution also this can be recommended. So there is a serious erosion of the faith in the federalism by the interpretation of Supreme Court. Probably time will come, political discussion should take place, ideological opinions have to be formed, wherein it has to be emphasized against the will of the people of the state. The state should not be divided or abrogated in an unreasonable manner to destabilize the federal construct of the constitution. This is the one answer with respect to the relation between the union and state. Coming to the second issue about borrowings, it is like a coin. It is a two sides of the coin, head and flower. Whether the states are right in borrowing, because as I told you, much of the welfare measures have to be implemented by the state, especially police powers, education, health, sanitation. All these responsibilities as per the constitutions are the state. Therefore, the state has to address the immediate needs and requirements of the people. So when you look at the constitution is divided into two parts, part 3 and part 4. Part 3 talks about existence of the citizens' rights. Part 4 of the constitution talks about excellence. Now we are moving towards a merger of existence and excellence. Therefore, the requirements of the state to spend more money is getting increased. But at the same time, you all are aware there are litigation in the Supreme Court questioning the free fee scheme introduced by the state governments. Is it fiscal prudence? Is it permitted? Can we have alternative thinkings? So these are the discussion in the context of fiscal federalism you people have to analyze. There is a divided thoughts. What extent the free fees can go, whether it is really helping the need of the people. Are we doing any statistics? For example, now Tamil Nadu government has introduced a scheme of giving 1,000 rupees. They put a lot of checks and balances. Some criteria has been evolved. Though we have more than 2.2 crore ration cards, the benefit has been given only to 1.25 crore. So who is the real needy? Because when you look at the constitution, we talk about economic justice. Justice has to be given only to the person, those who are in need of justice. So when we talk about welfare measures, you take Tamil Nadu government welfare measures. We are given free mixie, free TV. Prior to that, what we have done? Have we done any study? How many households are having TV? How many households are having mixies? No, we have not done study. So in the name of populism, sometimes we overspend. So therefore, the governance should be more of scientific tools, data-based governance. You take the Manrega scheme. The object and the scheme is very noble. The central government has introduced a scheme to protect and assure and guarantee employment in rural area. But in reality, what is happening? You go to a village, people will be assembling in a particular place, they will be enrolled, some money would be paid, partly someone takes over. So how to redress how to bring efficiency? To bring efficiency, we should have further discussion. Each panchayat, what are the works expected? When the works can be allocated? During agriculture season, can this work be given to the people or not? Like that, we should have alternative discussion to bring up efficiency in the fiscal administration. Unfortunately, now we are doing on random basis. That is also causing inconvenience or adding burden to the states. So now you know, government of West Bengal, government of Punjab, government of Kerala, they all file litigation before the Supreme Court, and now the matter is pending before the Supreme Court with respect to borrowing powers. So more discussion should be there. Prudence should be there with the union. Everyone is aware the union is lopsided, arbitrary and one-sided. But at the same time, it is the responsibility of the state also to adopt prudence approach, assure delivery of system, and corruption-free administration, then only you can gain confidence in the people. Therefore, more database structured administration, text-based solutions, transparent and verifiable data should be there to implement the scheme, which can create a fairness in the governance with respect to fiscal federalism.
Only one point about, whether the state can be broken into 2, 3, or union territory can be created. These are all no doubt a political question, because these are all done on the basis of the Indian constitutionalism that you can find in Article 1 of the Constitution. That India, that is Bharat, shall be the union of states, plural. Only one reference is there. That means you can put one South India, another state North India, that ends the matter and it qualifies for federalism, if you take it literally. Because the constitutionalism of USA is totally different. You all know that it is the indestructible union of indestructible states. But our constitutionalism is totally different. It has been misused, no doubt about that, but what to do? And you have to change perhaps, Article 1, if that is the case, with all conditionalities. Whatever the procedural powers given there, in anywhere else in the Constitution, that doesn't help in a big way. Thank you.
I think this would be the last question. And mic கொடுங்க. எங்க mic இல்லங்க போச்சு?
Good afternoon, sir. I'm Aishwarya from School of Excellence in Law. My question is, there is a lack of accountability and transparency of funds devolution in the divisible pool, and your opinion on the same. And one more question is like whether the state allocations on criteria of devolution of the taxes may lead to the change in the formula for the devolution in the upcoming 16th Finance Commission. Is there any possibility?
More than the non-transparency in the devolution, the more serious issue is the shrinking of the divisible pool itself. Okay, now 10 years ago, the cess and surcharge, how much was it collected and what it constituted, how much of the portion, and now how much do they collect and what is its size? Today, it's something like nearly 20% of 20 or 22% of the divisible pool. They take away in the name of cess. And if you take it over a period of time, it comes to some mind-boggling number. How much money has been pumped out of the divisible pool and exclusively being used by the union for its own ends. Now, the argument put forth by the Finance Minister, Honorable Finance Minister, is that we have a legitimate right, we have the right to levy a cess. That is fine. But what they refuse to tell you is how states are being bypassed. Now they say that for that they say that anyway we are going to spend it only in the projects that concerns the states only. But the question is, when it devolves through the Finance Commission allocation, then it is not tied. Whereas when it is given the other way around, on the other channels, it's all tied. Like for instance, if you take the housing scheme, the rural housing scheme, you know that we have been constructing houses for the rural poor for a very long time, and the present day name for that scheme is Prime Minister Awas Yojana, PMAY. The union government keeps on announcing, no, we will construct this many units, that many units. But the unit cost that they allocate to the states to construct one unit of house is somewhere around 72,000 rupees. Can you construct a house for 72,000 rupees? Now, it is the duty of the state to put in more money. How much money we put in more? We put in more like something like 2.5 lakhs for each unit. That is for the rural houses. If you take the urban houses, it is much worse. What they give is something like 1 lakh, whereas the state government has to put in 14 lakhs, and that is not enough. You have to get money from the beneficiaries as well to complete one unit. So what the union government does is, on the one hand, by imposing cess and surcharge, it reduces the divisible pool nearly by 1/4. That is, so automatically the money that gets transferred through devolution will come down for all the states. Forget about any one state. That is one. Secondly, by amassing that much of resources with itself, then it has its own discretion to spend money wherever they want to. That's what Jyoti was referring to. Like, if you are supporting us, we will give you more money. But through devolution, you can't do that. Second question you are asking about is whether the Finance Commission, the latest one, will change the formula of devolution. Every time they do that, okay. But if you take the overall numbers, you realize that the well-performing states in terms of population control and development, they tend to lose money in the name of equity. That's what is happening in the name of different things. So they will work out various combinations, which criteria to take, which criteria not to take. And at the end of the day, what is the net picture? The net picture is all the developed ones will lose. That is why this popular argument that for every rupee that you collect from here, the money that comes back is hardly one third or less than that. So the argument is that we can't say that if you pay 1 rupee, we have to get back 1 rupee. You can't say that. But the counter argument to this is, when you evolve the criteria, you should also consider the requirements of the developed states as well. Like, for instance, if you take Tamil Nadu, you know pretty well that Tamil Nadu is the most urbanized state. Now, urban population must have crossed 50%. Now, when half of the population lives in urban areas, it is the duty of the state government to provide the infrastructure that is required for the urban population. Now, if you take Chennai, you have so many areas where we are unable to provide the underground drainage system, sewage system. We are unable to provide pumped drinking water. You need massive investments for each one of these. And we do not have that kind of money. Like, for instance, if the union government is willing to provide its equity and convert the Metro Rail Phase 2 project as its own, as a central sector project, then we are relieved of the space of nearly 70,000 crores, which means so many urban places can be provided with all this infrastructure. Now, by adopting these kind of practices, what they do is they squeeze the space that is available for the state governments to function, financially squeeze you. That is dictated by the politics of the day. This is not new to the Indian federal structure. This has been the case right from day one. So, all these vertical and horizontal imbalances are, at the end of the day, is a political bargain which is being negotiated. Not at the Finance Commission level, but beyond that as well. So with that answer, I think we will close the session. Thank you very much for this opportunity. I thank Professor Chokkalingam, the Dean of Law School, for organizing this international workshop and also for inviting all of us for this panel discussion. Thank you so much.
Respected and esteemed panelists, thank you very much for patiently addressing the queries of our participants. Your deliberation and discussion over the topic has extended the scope for further research. It is now time to felicitate all the dignitaries. May I now request our Dean, Professor Dr. C. Chokkalingam, sir, to present a book to our panelist, Dr. J. Jayaranjan, Vice Chairman, Tamil Nadu State Planning Commission. I request our Dean, sir, to present a book to Professor Dr. M. Gandhi, Professor and Executive Director, Jindal Global Law School. As a token of gratitude, we now present a book to Professor Dr. R. Srinivasan, full-time member, Tamil Nadu State Planning Commission. We would like to now present a book to Professor K. Jyoti Shivanyanam, member, Tamil Nadu Public Service Commission. May I now request our Dean Sir to present the book to Dr. C. Manikam, ex-IRS founder and director, Tax Law and IPR Consultants. Respected and esteemed panelists, as we balance the book on today's enlightening panel discussion, we express our deepest gratitude for your distinguished presence and invaluable contributions. Coming together is a beginning, keeping together is a progress. Working together is success. Your collective wisdom and expertise navigated the complexities of fiscal federalism with remarkable clarity, illuminating crucial aspects such as intergovernmental fiscal relations, subnational fiscal autonomy, resource mobilization and allocation, fiscal policy coordination. Your esteemed expertise helped us bridge the fiscal gap between theory and practice and shed light on the nuances of center-state financial relations. We are indebted to your generosity in sharing your perspectives, experiences and knowledge, which have greatly invested in our understanding of fiscal federalism. We humbly appreciate how your deliberations have funded our curiosity and are grateful for the returns on our investment in this conference. Your contributions have been instrumental in shaping our understanding of fiscal federalism's role in promoting economic development and social justice. With profound respect, we thank you for your time, energy and dedication. Thank you. We will now disperse for lunch and get back at 2:15 in Seminar Hall 1 here for the valedictory session.
Good afternoon, everyone. It's truly a pleasure to welcome you all to the valedictory session of our international conference on fiscal federalism with special reference to Indian Constitution. Over the past 2 days, we have had the privilege of learning from remarkable speakers, engaging in thought-provoking discussions, and connecting with colleagues from around. Welcome to our esteemed guests whose support has made this event a grand success. It gives me a great honor to welcome Honorable Justice Mr. Ibrahim Khalifullah, former Judge, Supreme Court of India, to the valedictory session of our conference. I want to express my heartfelt gratitude for taking your time and joining us today, sir. I welcome Professor Dr. N. Raja Hussain, Registrar, B.S. Abdur Rahman Crescent Institute of Science and Technology, for joining us today. And I welcome all the dignitaries for joining and gracing this event. I welcome you all once again. Thank you. Before we begin, let us take a moment to invoke the blessings from above. Now, I call upon Aisha to recite the Qiraat.
Assalamu alaikum wa rahmatullahi wa barakatuh. Bismillahir Rahmanir Rahim. Wal duha wal layli idha saja ma waddaka rabbuka wa ma qala walal akhiratu khairul laka minal ula wala sawfa yu'tika rabbuka fatarda alam yajidika yatiman fa'awa wa wajadaka dhallan fahada wa wajadaka a'ilan fa'agna فأما اليتيم فلا تقهر وأما السائل فلا تنهر وأما بنعمة ربك فحدث. Translation. In the name of Allah, the most beneficent, the most merciful. By the morning brightness and by the night when it covers with darkness, your Lord has not taken leave of you, nor has he detested. And the hereafter is better for you than the first. And your Lord is going to give you, and you will be satisfied. Did he not find you an orphan and give you refuge? And he found you lost and guided. And he found you poor and made self-sufficient. So as for the orphan, do not oppress. And as for the petitioner, do not repair. But as for the favor of your Lord, report. Jazakallah.
I request everyone to please raise up for the Tamil Taivarthu.
நீராரும் கடலுடுத்த நிலமடந்த கெழிலொழுகும் சீராரும் வதனமென திகழ்பரத கண்டமிது தெக்கனமும் அது சிறந்த திராவிடனல் திருநாடும் தக்க சிறு பிறை நுதலும் தரித்தனரும் திலகமுமே அத்திலக வாசனை போல் அனைத்துலகும் இன்பமுற எத்திசையும் புகழ் மணக்க இருந்த பெரும் தமிழனங்கே தமிழனங்கே உன் சீரிழமை திறம்பியல்ந்து செயல் மறந்து வாழ்த்ததுமே வாழ்த்ததுமே வாழ்த்ததுமே.
Thank you so much. It is my pleasure to introduce a distinguished member of our academic community. Please welcome Dr. M.A. Salim Ahmed, Assistant Professor, Crescent School of Law, to deliver the welcome address.
Good afternoon, esteemed guests,
respected dignitaries, faculty members, students, and all those present. It's my great honor to deliver the welcome address for the valedictory section of the International Conference on Fiscal Federalism with special reference to Indian Constitution. After 2 days of enlightened deliberations and discussions, and thought-provoking discussions, we are here to celebrate the successful conclusion of this important event. First and foremost, I extend a warm and special welcome to our esteemed Chief Guest, Honorable Justice Mr. Ibrahim Khalifullah, former Judge of Supreme Court of India. I welcome you, sir. Your presence today is truly a honor for us, and we look forward for your valedictory address. I would like to extend a warm welcome to Professor Dr. N. Raja Hussain, Registrar of B.S. Abdur Rahman Crescent Institute of Science and Technology. I welcome you, sir. Your dedicated efforts in managing the administrative aspects of this institution have ensured the smooth coordination of this conference. I would like to acknowledge the tremendous contribution of Professor Dr. C. Chokkalingam, Dean, Crescent School of Law. I welcome you, sir. Your leadership and commitment to this event have been instrumental in its success. A heartfelt welcome to Professor Dr. A. Vijayalakshmi Ramalingam, our dedicated conference coordinator. I welcome you, ma'am. Your hard work, attention to detail, and seamless organization have made International Conference a grand success. I would like to extend my hearty welcome to Dr. M. Shamima Parveen and Ms. I. Samsul Samira for their contribution to their International Conference. A warm welcome to Dr. C. Manikam sir. He is not only a distinguished panelist but also a generous sponsor of this conference. I welcome you, sir. Your support and contribution have greatly enriched the quality of this event. To all our distinguished panel members and resource persons, your invaluable insights and expertise have added immense depth to the discussion. I welcome you all. And to our enthusiastic students, dedicated faculty members, and supportive staffs, I welcome you all. Your active engagement has brought energy and meaning to this conference. As we begin with this valedictory session, I invite everyone to reflect on the knowledge and ideas exchanged over past 2 days. I am confident that the insight gained here will inspire further discussion and research in the area of fiscal federalism. Thank you all once again.
Thank you, sir, for the insightful and inspiring welcome address. The reflections you shared has beautifully captured the essence of our conference and the journey we have shared over the past 2 days. It's evident that your words have set a meaningful tone for our discussion today, reminding us the importance of fiscal federalism with special reference to Indian Constitution. As we wrap up this conference, let's carry forward the valuable lessons you have shared and continue to foster the spirit of collaboration and innovation. Once again, thank you so much, sir. Now, I request our Registrar, Professor Dr. N. Raja Hussain, to felicitate our Chief Guest, Justice Mr. Ibrahim Khalifullah. I also request our Dean to join him in felicitating. Thank you so much, sir.
It's both an honor and a privilege to introduce our distinguished guest, the Honorable Justice Mr. Ibrahim Khalifullah, sir, former Justice of the Supreme Court. Lordship was standing counsel for the Tamil Nadu Electricity Board, and later his Lordship was appointed as permanent judge of the Madras High Court. After assumption of office, learned judge has rendered many landmark judgments. In one case relating to election to a local body, namely the Chennai City Corporation, sitting in a division bench, the learned judge rendered a dissenting judgment holding that the election in respect of 99 wards was able to led by a side. And the matter was referred to a third judge, and the third judge also confirmed the view of Justice Ibrahim Khalifullah sir. His commitment to justice and equality has shaped the legal landscape of our nation. Justice was then transferred to High Court of Jammu and Kashmir and assumed the charge of office on 24th Feb 2011 and was later appointed as Acting Chief Justice of High Court of Jammu and Kashmir on 7th April 2011. And on 18 2009, Justice took his oath as Chief Justice of High Court of Jammu and Kashmir and was then elevated as the Judge, the Supreme Court of India on 2nd April 2012. Later, he was retired on office from 22nd July 2016. Justice Ibrahim Khalifullah's work has not only influenced the court, but has also inspired countless individuals in the field of law and beyond. Today, we are eager to hear your insights as we reflect on our conference and the important discussions we have had. So without wasting much time, please join me in welcoming Justice Ibrahim Khalifullah sir to the stage to deliver the valedictory address.
Assalamu alaikum and good evening to all of you. I think you are all tired. That's why you are not able to respond to my wishes. My gentleman here, he is only giving me the real salam. Anyway, you are bound to be tired because from morning you are all sitting here. Therefore, I should not expect that amount of zeal and agility at this point of time. In the name of Almighty Allah, the most beneficent and merciful, I may cover, because this being a valedictory address and the topic, the theme, which was conceptualized by the university and the Crescent School of Law, is so very heavy and meaningful and very intrinsic. I myself wanted to learn. I was not a tax lawyer. I was practicing on the labor side. But my senior, Mr. T.S. Gopalan, he used to tell me, if you are strong on the fundamentals, you can deal with any subject. What all you require is to understand the concept, learn, and then deliver. With this small prelude, let me commence. I am very happy, really, and proud to be amongst you today on a 2 days international conference successfully held on fiscal federalism, with a special reference to the Constitution of India. Dr. B.S. Abdul Rahman, Crescent Institute of Science and Technology, is such a very well-established university. It is, for them, it is just holding any conference on any aspect is so very simple, comfortable, convenient, and they don't strain themselves. And especially the Crescent School of Law as its host, they have organized this conference so well. It is really very exciting to watch all of you who have participated in the seminar, 2 sessions yesterday, 3 sessions, 2 yesterday and 1 interactive session this morning. So altogether 3 sessions, and the faculty, the speakers whom I have noted from the invitation were all of very high caliber, very high caliber. And they must have been, they are all experts, and many of them are experts in the field of GST. Therefore, they would have definitely sowed the inputs, very heavy inputs on all of you. So, the subject is intertwined. We all should know that GST is intertwined with the lives of human beings. Like food, we can't exist without the imposition of GST. Every day when we go and buy something or other, we find that there is an element of GST there. Either SGST or CGST, goods and services tax. Therefore, it is now, it is in the global landscape, this phenomenon has become very vital and is holding the field. I'm thankful to Dr. Chokalingam for having thought of me to address this valedictory session. The Dean of the Crescent School of Law. I also thank Professor Dr. Murugesan, Professor Dr. Tajuddin, Professor Dr. Vijayalakshmi Ramalingam, Dr. M.A. Sabir Ahmad, Salim Ahmad, Assistant Professor Ibrahim Samsul Samira. I asked her, she came along with Dr. Chokalingam to invite me, and then I asked her, I presented a book to her, the book which was a translation of my lectures in Tamil. Sattathin Peedu Nadai, Munsellum Madan Padai, the March of Law. I gave it to her and I wanted to know her initials, and she said, my initial is your name, my lord, she said. Therefore, I know her full name, Ibrahim Samsul Samira, Professor, and Dr. Shamima Parveen. She is also from the judiciary. I think her father, Jafarullah, is known to me for more than 30 years. He is from my native place, Annavasal. That's how Shamima Parveen is also close to me. Dr. Amit Lingam, the Vice Chancellor of Dr. Tamil Nadu National Law University, Srirangam. Srirangam, yes, please take your seat. And my good old friend, Mr. Rahman is not there without Mr. Jalal. If it is Crescent, what immediately occurs to us used to be Mr. Jalal, and now Mr. Dr. Raja Hussain. He has, because he has become 88 years old. Mr. Jalal, I asked him, he said 88 years. And he is hale and healthy by God's grace. There is nothing, no exclusion, sweet, everything he is taking. We will pray for his long life. and continued support to this great institution. Yes. I saw the gentleman who addressed these sessions, and I take great pleasure in acknowledging their involvement in this seminar. Professor Dr. N.S. Santosh Kumar, Professor Dr. V. Vijay Kumar, who I think they all addressed this inaugural address. Yes. All the participants, all of you here, other faculties, I am not able to mention the name of every one of them. They deserve the greatest honor, being the faculties of this great institution. In these 2 days, the sessions, the debates and discussions were on the impact of GST. I would like to make this valedictory address a more simplest and understandable to me. You are all brilliant, but my knowledge on tax law is very, very limited. Though I sat in the tax bench in the Madras High Court for 1 full year, I told the other day, the most cumbersome, complicated law is the Income Tax Act. Any other subject you can handle it, any other law provisions you can easily read and consume it, you can understand it quickly. But Income Tax Act is the most cumbersome, complicated provision. Why I am saying, if you happen to touch that book, don't try. You will find it very difficult. If you happen to touch that book, just to go through just 5 or 6 sections in the beginning, you will find in every section they will have 1A, 1B, 1G, 1D, and 1AA, 1BB, 1CC, 1DD, like that. Such a complicated provision. And in every section there will be very many provisos, very many explanations, and it will be very difficult for us to correlate the provisions and the connected relevant other provisions to understand the issue in tax law. But the lawyers, the future budding lawyers, all of you, I am telling you, whomsoever is going to practice on the tax side, I am confident that you will be able to assist the court. And I have seen the revenue bar assisting me, my bench, in such a way, made the job so easy. They will just place the provision so nicely, correlate it, and make me understand the issue, and then enable me to deliver the judgment. What I used to do in that 1 full year, I never used to reserve orders, because if I reserve orders, it will be difficult for me to again regain what are they said. Therefore, I will hear them, just conserve it in my brain, and then immediately I will deliver the judgment. That's how I was managing for 1 full year. Fortunately for me, there was one Chief Justice sitting in the Supreme Court. And that judge was an expert in tax law. Therefore, whenever the orders were taken to the Supreme Court, that Honorable Chief Justice, because he was sitting in the tax bench there, so whenever my orders were challenged, it went before him. And he saw, and then he felt that, oh, this man is a taxman. I was not. He was so impressed. He asked one of the senior advocates who went there, who is that man? Who is that Justice Ibrahim Khalifullah. Yeah, he is a very good judge. Yeah, I have seen his orders. So my name got registered in his mind, and that paved the way for my further elevation to the Supreme Court. See the... Don't think I am trying to divert from the subject. No. Yeah. And that Chief Justice of India was none other than Justice Kapadia. The great, great judge. I am going to quote him here. Why? Because, you see, Leonardo da Vinci, he said, I quote, learning is the only thing the mind never exhausts, never fears, and never regrets. That is the only thing the mind never gets exhausted. It doesn't fear also, and it never regrets. You see, the process of learning, unquote, the process of learning starts from our childhood till we breathe our last. The process continues. In America, there was a study made about the infants. At what point of time these children start learning. And then in the research they found that the child starts learning from its 8th month onwards. Of course, I would say that it starts the moment it comes out of the fetus, and then because it searches for its food, it learns where it will get it. That's how it starts. But anyway, a visible learning, the Americans, they have found at the age of 8, if you throw some 4-5 toys before the child, they have found out that the child will pick the brightest one, the brightest of the toys which was placed before it. It chooses the color. Then you will find the child, you can test it in your house itself if you have small kids. It will just turn around, look at the object in different dimensions. The third process will be taste. The child will try to taste it. And then the last process, once the child finds there is nothing in it, it doesn't even taste good, breaks it. This is the process of learning of children. So the process of learning starts from our childhood and till our last breath we learn. Justice Kapadia, when he addressed our Tamil Nadu State Judicial Academy, he told us every subject, every matter, every issue, it consists of, he said, concepts. He said, every issue consists of different concepts. And he said, the process of learning is understanding these concepts. And once we are clear of the concepts of every subject, here we are concerned with this fiscal federalism vis-a-vis our Indian constitution and disaster management. So I will come to the concepts, the broad concepts. Before that, let me explain what Justice Kapadia told us and my subordinate judiciary. He said, every matter, every issue has got different concepts And if you are clear of the if you are not clear of the concept, you are bound to fail. You will not be successful. Therefore, the concepts should be identified. The concept should be identified in every issue, every matter, and then you should try to understand the concepts. And once the concepts are understood, then you gain the full knowledge of the whole issue by virtue of the different concepts having been very clear in your mind. Let me try to analyze the various concepts involved and integrated in the theme of this international conference. And I am confident by virtue of the great personalities who addressed you by this time, most of you would have been very clear about the concepts, but yet I will try to inject some more inputs, which and what I have learned is from my own law clerk. I asked my law clerk, because I had a very tight schedule for the past 2-3 days. Dr. Chokkalingam, though I thank him, he did not give me much time about the theme. Therefore, I had a very short time. Therefore, I requested my law clerk, please gather the materials and give it to me. He's such a very intelligent lawyer. She had her MBA in Canada and her law here in Madras, and she is now assisting me in many of my assignments. So she gave me the full materials on the subject, and I have analyzed that, and that I am now placing it before you. Therefore, I am thankful to her, my law clerk, Miss Vinitra. In Tamil it is said, it is mere understanding of the concept, that is, knowledge by itself will not be sufficient. You must understand the concepts, you should have the knowledge. And the book which I gave to Samira, it was released in Madurai by the Madurai Bar Association, and it was released by our former Chief Justice, Justice Sanjay Gangapurwala, and he is from Aurangabad. Such a great, intelligent and brilliant judge. That day I learnt this another concept on knowledge. He said, while releasing it, after releasing it, he said, Justice Khalifullah has, because I gave him the English version of my book and he read that, and he said in his address, Justice Khalifullah has his lectures contained in this book are very, very informative, knowledgeable. And then he said, it is also coupled with wisdom. Therefore, that day I learnt, mere possession of knowledge is not sufficient. From what Justice Gangapurwala said, we should also have wisdom. In Tamil it is said, Arivu mattum irundal pattadu, Arivodu ஞானமும் வேணும். ஞானம் கூட இருந்தாதான் அந்த அறிவு பயன்படும். Therefore, knowledge and wisdom should go together side by side. If you were to master any subject, understand any subject, use it in your future career. So, keeping above the preludes, let me come to the concepts. I don't want to try your patience anymore. The concepts I have found are federalism, fiscal autonomy, coupled with constitutional provisions. framework and disaster management. Let us try to dissect these concepts. Each of the concepts, let us try to go deep into it. I won't be able to, already it is nearing 4 o'clock. Therefore, I may not be able to cover all the concepts in one go. But at least if I am able to cover federalism, fiscal autonomy, and the constitutional framework, rest of it I am sure you all will be able to, you are all experts, you all have gained the greatest knowledge for the past 2 days on this subject. You will be able to make it up. See, when we try to understand the fiscal federalism, it's very simple. I asked Samira, what is fiscal federalism? I asked her just like that. And she told me, my lord, in a federal setup, how the fiscal, financial matter is being dealt with. In a very, very simple way, she gave me the, I appreciate it. That is the skill of a teacher. She taught me what is fiscal federalism. See? That's all. That is fiscal federalism. The concept is so very simple. Our country is a federal country because it consists of states and the center. How the distribution of this finance is to be dealt with is fiscal federalism. That's simple, so simple. See, therefore, in this concept, there are macro, micro control over planning, administration, accountability, resource allocation. These are all the side concepts, sub-concepts. Micro, macro aspects that are control over planning, administration, accountability, resource allocation, and effective policies and innovations. I found out these were the sub-concepts involved in this fiscal federalism. See, the outcome you will find, I will try to make it very, very simple. The outcome of this understanding of this concept, you will find 2 questions. Number 1, whether the fiscal divide, the revenue division between the center and the state is sufficient. When we try to understand fiscal federalism, this question will arise. Whether the fiscal divide between the center and the state is sufficient. One other question which will arise here would be whether the autonomy exists. It is not merely division. Whether the autonomy exists between center and the state in their decision-making process with regard to fiscal decisions, even in times of, that is where the third concept, disaster management, comes. See, when we were facing this COVID problem, so what happened? See, the Honorable Supreme Court, exercising its supreme power under Article 142 of the Constitution, what did it do? It simply said, from now on, no limitation. It passed an order. See, there was disaster everywhere. People were all locked up in the houses. And how will anyone exercise their legal rights vis-a-vis their counterpart, litigations, if they have any claim against anyone, and if it is barred by limitation during this period, what will happen to their rights? The Supreme Court came forward with an omnibus order, one single order passed in sometime in February 2020. All limitations suspended, and which was ultimately that omnibus order was put to an end in 2022, February 2022. All cases, everyone were relieved. Therefore, with regard to this fiscal federalism, at times of disasters, how this fiscal, the distribution of this revenue, in what way it should it should reach the people, how it should grant relief to the respective states who ultimately have to take care of their subjects. See, in this background, if we come to this the concept fiscal federalism vis-a-vis the constitutional provision, it's section Article 265 of the Constitution says that no tax shall be levied or collected except by authority of law. Therefore, the state on the one side, center on the one side, and the collection of the revenue, every should be within the framework of law. That is where the Constitution comes into, the role of Constitution comes into play. See, Article 265 says, there shall be no tax levied except by authority of law. And then you will find in the Constitution, list 1 of the 7th schedule, list 2 of the 7th schedule, list 3 of the 7th schedule. Therefore, the formulation of laws it will have to be restricted to whatever subjects mentioned in list 1 insofar as the center is concerned. Insofar as state is concerned, subjects mentioned in list 2, and both have powers in respect of subjects mentioned in list 3. Therefore, the creation of the law should be within the framework of these very, very, very important provisions. Then, now let us try to go a little more deep into this GST. What is this? Goods and services, material things and services. Services can be of material as well as intellect. The other day, my electrician came. My wife asked him, there is some leakage somewhere. And I didn't know. 2 days later, he sends me a message, sir, 1,500 due for services. See, these services are assessed. Similarly, the goods are assessed. Therefore, the goods and services tax. This innovation, see, prior to this GST, we were all, I don't know whether you are all aware of the previous regime, tax regime, we had Tamil Nadu TNGST, Tamil Nadu General Sales Tax Act, and Central Sales Tax Act. There used to be every shop owner used to get a registration under the TNGST Act and the CST Act if he was dealing with interstate transactions. That was the regime before. And this GST, Goods and Services Tax, see that previously the state, the collection of tax were mostly on sale and purchase, excise duty on liquor, opium, narcotics, taxes on luxuries, entertainment, and then amusements, betting, so on, and so far as the state was concerned. Octroi, that is entry tax, electricity tax, and so on. As far as this indirect tax was concerned, and so far as center was concerned, it was mainly CST, customs duty, excise duty, and so on. When we try to understand this concept of GST vis-a-vis the previous regime, there is a very fundamental aspect involved. That is, the common phenomenon would be insofar as the previous regime was concerned, it used to be on the GST, how to put it, it was a destination-based consumption. See, the introduction of GST has created a more easier system of computation when compared to the complex variables, so many things involved that existed prior to its introduction. It was only in the year 2000 the concept of GST was thought of, and a committee was set up to design a GST model. Then again in 2003, the central government, it formed a task force on fiscal responsibility and budget management, in which that task force in 2004, it recommended this GST, introduction of GST to replace this existing tax regime. And it had, that report disclosed that it had very many hurdles to face. There were a number of thorny issues. The tax reform, as vast as GST is concerned, India's, because we have very many states of different revenue availability. One state is poorer, one state is richer. Therefore, there were very many hurdles, thorny issues, which was faced by the task force. And one major issue in the run on GST was the origin-based vis-a-vis the destination-based taxation. So we will have to understand this origin-based concept and the destination-based concept. See, under destination-based concept, the difference you will find, the destination-based concept, the taxation, the tax accrues to the destination place, whereas the consumption of goods or services takes place. Therefore, at what point of time the liability of tax will occur? Many manufacturing states, they expressed their concern that was faced by this task force over the loss of revenue on account of this shift from origin based to destination based. Ultimately, the states, just to appease the states, the government said liquor was kept out of GST regime. Because mostly you will find the liquor is dependent upon the local situations prevailing. Therefore, and it generates more revenue. Therefore, the states were the liquor was kept out of the GST regime. There you will find this concept of fiscal autonomy. See, when the center wants to keep it aside from the GST regime, it recognizes the fiscal autonomy of the state. So that is how we understand in fiscal federalism, in the light of the constitutional framework, the fiscal autonomy also comes into play. See, then it was felt, suppose if there is a dispute between the state and center as to how far the GST allocation is to be worked out. Then again, how to resolve it. Then it was thought that the Goods and Services Tax Council can look into these disputes and sort it out. But then it was felt that it will be arbitrary. Who is it? Who are there to determine our rights? Therefore, an attempt was made to bring about an amendment which is called the 110th Amendment Bill, which wanted to set up a dispute resolution body. When it was thought of, there was a challenge, because that dispute resolution body, suppose the state is related to the allocation of the revenue on particular item, the dispute. And if it goes before the dispute resolution body, it becomes a judicial body, and then which will usurp the powers of the parliament, the legislature, the law-making body. And therefore, when that opposition, that challenge was made, this 110th Amendment Bill was allowed to die. Then the Parliament introduced the Constitution 122nd Amendment Bill in 2014, which suggested a service tax council may decide about the dispute, the modalities, and to resolve whatever dispute. And there were challenges to that also. Thereafter, the changes were brought about by this 101st Amendment Act to the Constitution. In the Constitution, when we deal with fiscal federalism, fiscal autonomy, these provisions which were introduced in the 101st Amendment of the Constitution, by which, tell you, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 amendments were introduced. There were insertions, there were omissions, and there were amendments to different articles of the Constitution in order to set right these teething problems in the introduction of the GST. See, these constitutional provisions you will find in chapter 12 under the heading Finance. It consists of provisions between Article 265 to 290 capital A. Then, what were the challenges? Let us try to find out the challenges which the state came across in dealing with fiscal federalism and fiscal autonomy. The challenges were because from the previous tax regime, GST has come into play. And it has caused a loss of tax revenue which dwindled to 35% in 2015-16 and again went down to 30% in 2023-24, which is revealed in the budget estimates. This is the impact of this new regime. And then anyway, as per budget estimate 2024-25, the gross tax revenue is estimated to be to grow at 11.7% over and about this 2023-24. Another challenge is the erosion of state tax autonomy. I don't want to go very deep into that because it may not be appreciated at my instance. Therefore, one of the challenges, and I leave it at that, that is erosion of state tax autonomy. Reduction in grants in aid, again a subject which I just mentioned and leave it at that. The transfer of union government's GTR has declined from 48.2% to 35.32%. These were all the challenges. So let us now come to what should be the way forward. See, it is suggested from the various materials, it is suggested that promoting competitive federalism along with cooperative federalism, the competitive federalism should also be promoted. This is one suggestion which has come out. See, the benchmarking and performance indication, incentive-based resource allocation, investment attractions, all should be, the parameters should promote the competence and federalism and fund allocation. This is how the present crisis, whatever deficiencies are there, can be accommodated or it can be solved, it can be set right by adopting these, by promoting this competitive federalism. Then the other one suggested is reform the Finance Commission and tax sharing mechanism. Again, it is not for me to suggest But what I have found by the search, I have found that these were all the suggestions for resolving the whatever deficiencies found out. See, another suggestion is enhance the institutional framework for fiscal federation. See, I have read in this business standard recently on 25/7/2024. They have in a very, very short form, they have come out with a suggestion. They say fiscal federalism in India is crucial for maintaining a balance between the center and the state center and the state's financial autonomy, ensuring equitable resource distribution, that it strengthens democratic governance by promoting local decision making and accountability while addressing regional disparities and fostering cooperative federalism. I think I cannot put it in more better way than what has been suggested in that magazine. Therefore, with these few ideas which occurred to my mind and sharing it with you on this fiscal federalism, financial autonomy vis-a-vis the constitutional provisions, and situations like disaster management, I leave it to this audience to work out further and try to learn much more than what little I have shared with you. Thank you very much for the opportunity.
Thank you, Justice, for that powerful, wonderful, and thought-provoking valedictory address. Your reflections on fiscal federalism, with special reference to Indian Constitution, resonate deeply with all of us and encapsulate the lasting impact on our community and inspire us to strive for excellence in our field. We once again thank you, Justice, for your time, your insights, and your valuable contributions to our gatherings. We are truly honored to have had you with us today. Thank you so much, sir. Now, it is my pleasure to introduce Ms. Samshul Samira, Assistant Professor, Crescent School of Law, to deliver the rapporteur.
Assalamu alaikum wa rahmatullahi wa barakatuhu. I'm very much honored to present the rapporteur of this international conference on fiscal federalism with special reference to Constitution of India. The prestigious B.S. Abdur Rahman Crescent Institute of Science and Technology is renowned for its unique way of inculcating technical and professional studies, wherein the wings of our Crescent School of Law have always been provided a widespread space like the open sky to explore. The vision of the law school is not only exhaustive to provide legal knowledge, but also to pave way for innovation, as a part of which this grand event of 2 days international conference on fiscal federalism with special reference to the Indian Constitution was successfully organized. The event kick-started with the registration process on the first day, followed by the inauguration ceremony, recitation of Kirat and Tamil Thai Walther by the students of CSL, followed by which the gathering was formally welcomed by our Dean, Crescent School of Law, Professor Dr. C. Chokkalingam, and presidential address by Vice Chancellor of BSA CIST, Professor Dr. T. Murugesan, Pro-Vice Chancellor, Professor Dr. N. Tajuddin, and Registrar, Professor Dr. N. Raja Hussain, has given the felicitation address. The event was inaugurated by the guest of honor, Colonel Professor Dr. N.S. Santosh Kumar, Vice Chancellor of Tamil Nadu Dr. Ambedkar Law University, who emphasized that GST is a bold move towards establishing the fiscal federalism in India. And he highlighted that India's cooperative and collaborative federalism. Thereafter, the keynote address was delivered by the chief guest, Professor Dr. V. Vijay Kumar, former Vice Chancellor, National Law University, Bhopal. The inauguration ceremony was concluded harmoniously with the delivery of the oath of thanks by Professor Dr. A. Vijayalakshmi Ramalingam. On the first day, that is the 27th September 2024, we had resourceful sessions. The first session was held from 12:45 to 1:30 on the theme Impact of GST on Federalism and Fiscal Autonomy, which was split into 1A and 1B. We had a esteemed panel of judges for session 1A at the auditorium, including Professor Dr. A. David Ambrose, former head Department of Legal Studies, University of Madras, Professor Dr. Gauri Ramesh, Registrar Tamil Nadu Dr. Ambedkar Law University, Professor Dr. S.M. Balakrishnan, Registrar Tamil Nadu Dr. Ambedkar Law University, Tirchi. And for session 1B, Professor A. Vijayalakshmi Ramalingam, the coordinator of Crescent School of Law, Dr. Mujahidul Islam Sir, Associate Professor of Tamil Nadu Dr. Ambedkar Law University, and Dr. Amir Majid, Assistant Professor, Crescent School of Law, were the respectful panel of judges who provided valuable insights which happened simultaneously in seminar hall. The participants explored the effects of GST on financial relationship between center and state, discussing both its challenges and benefits. Then we had a lunch break where delicious meals were provided for all the participants. Thereafter, the session 2 held. The second session was held with the theme of fiscal autonomy of states. Thereafter, in the morning of 28 September 2024, we had the constitutional framework and autonomy, wherein we had the esteemed guests, Dr. Narendran Agarwal, Associate Professor of Campus Law Center, Dr. G. Rajasekhar from University of Madras, Professor S. Amardalingam from Tamil Nadu National Law University, Trichy, Professor Anuradha Binuri, Director from Symbiosis Law School, Ms. Manasha Krishnakumar, and Ms. Mursalin from Crescent School of Law. A highly engaging and insightful panel discussion happened today's morning, featuring the notable figures Dr. J. Jayaranjan, Vice Chairman of TNSPC, Professor Dr. Srinivas, full-time member of TNSPC, Professor Dr. M. Gandhi, Professor and Executive Director of Jindal Global Law School, Professor K. Jyoti Shivanyanam from TNPSC, and Dr. C. Manikam, ex-IRS, Founder and Director of Tax Law and IPR Consultants. The primary objective of this session was to foster a productive dialogue among the complexities and nuances of fiscal federalism within the framework of India's constitutional structure. Finally, we are now in the valedictory session. We are extremely happy to have our guest of honor, Honorable Justice F.M. Ibrahim Khalifullah Sir. With all thanks to the Almighty Allah Subhanahu wa Ta'ala, and collective support and coordination of our respectful dignitaries, faculty members, student coordinators, volunteers, and everyone over here, this event is a smooth sail. I would now like to recollect the words of Dr. B.R. Ambedkar, who said, "Men are mortal, and so are ideas. An idea needs propagation as much as a plant needs watering. Otherwise, both will wither and die. We all as a team of one and the saplings of the legal knowledge marked it towards the survival of ideas through this resourceful event. I thank each and everyone for making this international conference a huge success." A small instruction, the university bus will leave the campus only by 4:45.
Thank you, ma'am. Thank you, ma'am. Imagine if laughter and charm had a name. Well, it's a fabulous 29-year-old dynamo, the queen of wit, everyone's favorite, Mrs. Samsul Samira, ma'am. Thank you, ma'am, for making this event a successful one. Now, I request Justice Ibrahim Khalifullah sir to present the award to the winners, and I request Professor Dr. Vijay Lakshmi Ramalingam ma'am to announce the Best Paper and Best Paper Presenter Award.
We would like to proudly announce that the son of our Honorable Justice F.M. Ibrahim Khalifullah Lordship, his son studied, is an alumni of B.S. Abdur Rahman Crescent Institute of Science and Technology. He has completed BE Computer Science from this prestigious university. Thereafter, he practiced law and he is a successful practicing lawyer. Yes, sir.
Thank you so much. I'm really happy to announce the results. For Best Research Paper, it goes to Ms. Aishwarya. She's from Tamil Nadu, Dr. Ambedkar Law University.
Please give a big round of applause. Congratulations, Ms. Aishwarya.
We are happy to announce the Best Paper Presenter, Ms. Nida Nassara, TA, CSI Institute of Legal Studies.
Congratulations, Nida Nasser. Happy researching. So I hope this conference pave way for further research to all of us.
It is my honor to introduce Dr. M. Shamima Parveen, Assistant Professor, Crescent School of Law, to deliver the vote of thanks.
Assalamu alaikum wa rahmatullahi barakatuhu. Good evening, everyone. It is indeed a great honor and privilege to stand before you today to extend my heartfelt vote of thanks on behalf of the organizing committee of this wonderful conference. As we come to the end of the enriching event, I would like to take a moment to acknowledge the contributions of the people who had made this conference success. First and foremost, I would like to express my deepest gratitude to President BSA Arif Bukhari sir, Chancellor Mrs. Kurat Jamila, Pro-Vice Chancellor, Pro-Chancellor Mr. Abdul Qadir Rahim Bukhari, Vice Chancellor Professor Dr. T. Murugesan sir, Pro-Vice Chancellor Professor Dr. N. Tajuddin, Register Professor Dr. N. Raja Hussain, General Manager VNA Jalal sir, for their invaluable support and leadership throughout the planning and execution of this event. I would also like to extend my sincere thanks to our guest of honor, former Supreme Court Judge, Justice Ibrahim Khalifullah sir. Sir, your presence today had immense value in this event, and we are truly honored for your insights and encouragement, and thank you for sharing your expertise and knowledge amongst the students. We would also like to thank Dr. C. Manikam, ex-IRS founder and director, Tax Laws, IPR consultant. Sir, your invaluable expertise in taxation and intellectual property rights have helped us with the event. Now, I would also like to turn my gratitude to the management of Crescent School of Law, especially our respected Dean, Professor Dr. Chokkalingam. Sir, your guidance, resource, and encouragement were essential in making this conference possible. Thank you, sir. A special thanks goes to Professor Dr. Vijay Lakshmi ma'am. Ma'am, your involvement, mentorship, keen insights have indispensable in stirring the academic context of this conference. I would also like to extend my thanks to all the faculty members of Crescent School of Law who had played a crucial role in smooth functioning of this conference. Your valuable contributions, unwavering support from brainstorming sessions to the final preparations have ensured everything that ran efficiently. A special mention to the faculty coordinators who worked tirelessly behind the scene to coordinate various sessions and aspects of the event. I would also like to recognize the efforts of non-teaching staffs who have worked diligently to ensure the logistics and administrative aspects of this conference, which was handled seamlessly. A special word of appreciation to Kadir sir, the auditorium and in charge. Sir, your attention to detail, ensuring all the technical and venue arrangements. Thank you. Of course, the event would not have been complete without active participation of all the students and participants of the conference. Your enthusiasm and engagement in the discussion has been fully inspiring. I would also like to convey my sincere thanks to the wonderful team of student volunteers who had helped in the organizing of the conference, which your hard work, commitment, and readiness to assist at every step played an integral role in the success of the event. Finally, I would also like to thank everyone present here. Your involvement, whether as a media, press, speaker, panelist, organizer, or a participant, has made this event truly successful. And once again, thank you for all, and we're looking forward for more such events in future.
Thank you, ma'am, for that heartfelt vote of thanks. Your recognition of contributions made by our speakers, organizers, and participants truly capture the spirit of this conference. Your words remind us of all the collaborative efforts that made this event possible and the importance of these connections we have formed. As we move forward, let us carry the spirit of gratitude and the collaboration into our future endeavors. Once again, thank you, ma'am, for your thoughtful reflections, for bringing our conference to a meaningful close. Now I request everyone to please raise up for national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल गंगा विंध्य हिमाचल यमुना गंगा उच्चल जगति तरंगा तब शुभ नामे जाहे तब शुभ